18, my lord. Hearing item, my lord. Here in this case, I am for the claimant respondents, my lord. I've informed that respondent number 1 claimant has died, my lord. So I have to take necessary steps, my lord. I will take immediately, my lord. Maybe taken up after a week, my lord.
Heard Mr. Peace from the learned counsel for the appellant.
No,
Learned
respondent
counsel
claimant.
for the
Respondent.
respondent.
Respondent
You are
claimant.
there.
I'm
Yes.
there, Lordship. One more submission I have to make. Name of Mr. R.K.D. Chaudhary, senior advocate, may be shown because government is involved and he had appeared last.
Also heard item number.
18.
18.
1-8.
Also heard Miss R.D. Majumdar, learned counsel for the appellant. It is submitted by learned counsel for the respondent that this who died?
Respondent number 1, my lord.
Respondent number died.
Claimant respondent number
One has expired, and as such, then the appellant shall have to take steps.
No,
It's not necessary, Lordship, because the legal eye is already there.
So I have
That
to
is what-
file an application for striking of his name, my lord.
So he prays for some time to taking appropriate steps in this regard. The prayer is allowed. Name of Mr. R.K. D. Chaudhary, learned Deputy Solicitor General of India, may be reflected as engaged
He
counsel.
appeared as government, some government advocate at that point of time. Though he is Deputy Solicitor General,
No, who is the party?
Government of Assam. So his name is to be shown, Lordship, otherwise in the hearing, he won't be there.
Name of Mr. R.K. D. Chaudhary may be shown as
Counsel for respondent number 1.
counsel for respondent number 1 in the
No, my lord. Yes, respondent number, my lord. 4.
counsel for respondent in the
four.
cause list henceforth.
Hello, Black.
But please, let's say we take it to item number 12 plots.
Yes.
Here, the applicant side has filed an interlocutory application regarding certain developments. So along with that, having received the copy, we have filed a affidavit in opposition objection. Yes, sir, yes, sir. But say, I pray for requisition of the said, but then please allow me the record lordship.
Call for I.
May I please, your lordship, also on behalf of Mr. S.K. Goswami, my lord, I am praying for item number 15 and 16. In item number 15, he is the appellant, my lord, for the appellant, my lord.
Lordship, I am in item number 16 for the applicant. On behalf of Mr. Jayakal.
দুটাতে আশা কম।
Heard Miss L. Sharma, learned counsel submitting on behalf of Mr. S.K. Goswami, learned counsel for the appellant in MAC appeal number 741/2018, as well as that of respondent in MAC appeal number 798/2022, who prays for an adjournment due to personal difficulty of the conducting counsel. Learned counsel for the other side has no objection to the same, hence the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed.
Fix a date.
No. Date, it will go to October, November. Let this matter be listed on 3rd of November.
Oh, bless you.
May it be pleased, your lordship, with the consent of the other side, I beg to mention item number 17 of daily list and item number 23 of supplementary list. Lordship, in item number 17, matter may be passed over for the day, and item number 23, it was wrongly listed in orders column, my lord. It may be listed in hearing column.
Item number 17, heard Miss M. Kolita, learned counsel for.
In item number 17, I am for the appellant, and in item number 23, I am for the
Counsel for the appellant, who prays for an adjournment on the ground of who prays for passing over the appeal for the day. She submits that she has informed learned counsel for the other side regarding her prayer. The prayer is allowed. In item number 23, Heard Miss M. Kalita, learned counsel for respondent, who submits that this matter has been wrongly listed in orders column. It ought to have been listed in hearing column as the appeal is ready for hearing. Prayer is allowed. Let this matter be listed after 4 weeks on a date to be fixed by registry.
That's it.
Similar or
Similar order in item number 24.
supplementary list, Your Lordship.
Supplementary. It is
It may be possible for the day, and Your Lordship, and matter may be fixed for hearing. TCR has been received, Your Lordship.
And Mr.
A Dev on behalf of the respondent, T Rathi.
What's her name?
M. Chatterjee.
Heard Miss M. Chatterjee, learned counsel for the appellant. Also heard Mr. A. Dev, appearing for respondent. It is submitted at bar that this matter is wrongly listed in orders column. It ought to have been listed in hearing column. The prayer is allowed. Let this matter be listed in for hearing after 4 weeks on a date to be fixed by registry.
Should a fixed date may be given because it is a long pending matter.
5th of November.
Much of.
May it please your lordship. My lord, today's list, I have item number 19, my lord. I am for the appellant and my learned friend is appearing for the respondents, my lord. In this case, my lord, I have checked the office note. Office note 21/7/2026 says that LCR has not been received, my lord. But the matter has been fixed for hearing, but LCR has not been, my lord.
Item
received.
number 19.
19, my lord.
Heard Mr. M. Sharma, learned counsel for the appellant. Also heard Mr. S. Datta, learned counsel for respondent number 3 and 4. On perusal of the office note dated
21/7/2026.
21/7/2026, it appears that the trial court records have not yet been received. Stop, issue reminder for the same. Registry to take steps for issuance of reminder. Let this matter be listed after 4 weeks on a date to be fixed. by
Obliged. Highly appreciated.
May it please your lordship. Your lordship, with your consent from other side, I beg to mention item number 26 to 30 of the today's supplementary list, your lordship. 26 to 30. I pray that your lordship, these matters may be taken up after 3 weeks.
Heard Ms. P. Thakur, learned counsel for the
Regarding, your lordship, regarding item number 30 and for the respondent number 1.
heard Ms. P. Thakur, learned counsel appearing on behalf of Mr. R. Goswami, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. She submits that she has informed learned counsel for the other side regarding her prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 4 weeks on a date to be fixed by registry. In item number 30, show the presence of Miss D. Das for the respondent. Separate or rules.
Lordship, kindly fix a date after 3 weeks for item number 30.
Item number 30 at the date diyo. 5th of November.
Lordship,
5th of November.
I am appearing for the item number 27. Lordship, a date may be fixed, Lordship.
Item number 27. Mr.
A.U. Ahmed, Lordship.
A.U. Ahmed appears for respondent. Date at the diyo. 5th of November. 28 B.J. Mohanto. You also want a date after 4 weeks.
Okay.
May it please your lordship. Lordship, may I pray for listing of a contempt case, lordship? Lordship, the matter is serious, lordship. The father is not allowed to meet with the child since last 2 years, lordship. After having order of family court and order of this honorable court. Can it be on Monday, my lord?
Contempt court.
Notice has been issued already, my lord. Contempt against FAO, my lord.
Court number 9. Contempt matters pertaining to civil bench 1. Court number 9. Court number 9.
The main case was FAO, my lord.
Please go through the
Pleasure,
roster.
lordship. May I please your lordship? I am going to mention 2 MSC appeal for order for listing, lordship. Any date on August?
5th of August.
Lordship.
May I please, Your Lordship? Yes, I pray for listing IA, Your Lordship, for orders. Can it be have on 29?
5th of August.
Lordship 29 or
5th
30?
of August.
Similar prayer also.
5th of
So,
August.
The concern of the others, I'd like to mention item number 2, my lord. Here, my lord, we're supposed to file, even though we took time to file our objection in the IA, my lord, we have some difficulties, so my lord, that I mention for 2 weeks, my lord, we'll file our objection in the IA.
And Mr.
M. Smith for the
M. Smith,
opposite purpose.
learned counsel for respondent number 1 to
I'm for the appellant, Lordship.
Right.
Interim order may be extended.
also at Mr.
J. Das.
J. Das, learned counsel for the appellant / applicant. Learned counsel for the respondent has prayed for some more time for filing written objection in the interlocutory application. The prayer is not opposed to by the learned counsel for the appellant / applicant. Hence, same is allowed. Let this matter be listed after 3 weeks on a date to be fixed by
Immediate, my lord. Date may be, because there's some urgency, my lord, because we have issued, we will
24th of August.
Interim order may.
The interim order shall continue till next day.
May I please, Your Lordship, I'd like to mention FAO 46 of 25. I'm appearing on behalf of Mr. H. Das.
For listing,
Yes,
orders call. 5th of August.
5th of August.
I'd like to mention the MSc appeal, my lord, the mediation is completed, agreement is also done, my lord, so the audits becomes the order, so judicial order.
7th August.
Seven.
May I please, Your Lordship? Lordship, I beg for listing of one MSc appeal and one IA in the admissions column.
7th August.
May it please your Lordship. Your Lordship, I beg to mention listing of 3 MFA in the orders column.
7th August.
7th August.
My lord, another MSc appeal in admission column, it should come 18 matters, my lord, it just
7th August.
7.
Orders.
Maybe the Lordship, I have for condonation of delay of 38 days, Lordship. In the filing of the MSc, that's been ordered in 19/12/2017. 1 and 2 is the driver and owner of the vehicle, offending vehicle. In item number 4, they appear, Lordship.
Your Lordship, in item number 3, I'm not appearing for the insurance company.
Who is appearing?
It was, issue has, notice has to be issued, Your Lordship.
Just to know one. Then Lordship, the issue notice to respond number 3, Lordship. And 1 and 2 already we take steps as per office note dated 21/7/2026. No AD card has an answer notice return back, Lordship.
Lordship, I'm appearing in item number 4 for reference number 2 and 3.
Just a minute. We are taking up item number 3. Yes, you.
In connected appeal, Lordship, he appeared for the as per the 1 and 2 in item number 3, Lordship.
Okay.
My learned friend.
Heard Mr. D.
Gogoi.
N.J. Gogoi, learned counsel for the applicant on perusal of office note dated 21/7/2026. It appears that service report in respect of notice issued to respondent number 1 and 2 is awaited. The registry is directed to place the postal tract consignment report of notice issued to respondent number 1 and 2 by speed post before this court on the next date fixed. It also appears that no steps has been taken for issuance of notice on respondent number 3. The applicant shall take steps for issuance of notice upon respondent number 3 by speed post as well as by usual mode within 3 days from the date of this order, returnable on 28th of August.
20th August.
In item number 4 also, the respondent number 1 and 2 in item 3, they appeal also.
Item number 4, I am taking it.
It was fixed for hearing. The last
Apply
occasion.
Item number 4, there is no. It is for,
In the in the same case, same judgment and order. In item number 3, Lordship.
no, item number 4, there is no delay.
Lordship, yes, there is no delay.
The appeal has been admitted.
Yes,
Admitted,
Your
Lordship.
Lordship. It was fixed for hearing.
Hearing.
On the last occasion.
So item number 4. Yeah, got documented. Item number 4, heard Mr. N.J. Gogoi, learned counsel for the appellant. Also heard Miss, what is your name? S. Day. For respondent number 2 and 3, as well as Mr. S. Dotto, appearing for respondent number.
For the appellant, Your Lordship, in item number 4.
Cut off. Heard Mr. S. Dotto, learned counsel for the appellant. Also heard Mr. Gogoi, you are appearing for? Mr. N.J. Gogoi, appearing for
It's for respondent.
respondent number 1,
One.
as well as Miss S. Day, appearing for respondent number 2 and 3. 2 and 3. This matter is ready for hearing. Hence, list this matter for hearing on August की date. In previous case, what was the date? On 28th August, along with MSC, case number 429/2018.
See, item 3, Lordship, 1 and 2 may be stuck down, Lordship. They are diver hand. We
Now let us wait for the service report.
respondent 3, Lordship.
No, on next date, if they don't appear, then we'll decide.
Oblige, Lordship.
Much of it.
Wait, please, Your Lordship. Your Lordship, it has wrongly been listed in the orders column. Can it be listed on the hearings column?
5, 6, and 7. You are appearing in
Your Lordship, in item number 5 and 6, I'm the appellant. And item number 7, I'm the respondent.
heard Mr.
A Dev.
A. Dev, learned counsel for the appellant in MFA. Why these are clubbed together?
Your Lordship, similar matter regards to terminal charges.
But facts are different.
Your Lordship, facts are different.
मतलब similar issue, my lord, terminal charge, my lord. My lord, perhaps, my lord, the order is common order is there.
Also heard Mr. What is your name?
HP Gwalam,
H.P. Gwala, appearing for the
railway.
respondent number 2.
S. Sharma, my lord, on behalf of B. Sharma, for item number 6 and
Also heard Ms. S. Sharma, appearing on behalf of Mr. B. Sharma, learned standing counsel NF Railway. Mr. Gwala, you are also appearing for railways.
My lord, I am for the, no, my lord.
respondent.
In the respondent number, my lord, in my lord, item number 7, my lord.
I am
My
the
lord,
appellant.
Mr. B. Sharma is the, my lord, appellant.
These appeals are ready for hearing. Hence, let these appeals be listed for hearing on 10th of November.
Obliged.
Deeply of
Wait, please, Lordship, your original records which are called for your that is the Assam as yet. And it is a matter of the year 80 to 83, your Lordship. And original record, our client, your Lordship, actually he searched the matter in the trial court, your Lordship. Trial court says actually matter record has been sent for.
Both of you are standing on wrong sides.
Yes, yes.
So therefore change your sides.
Anyone, no matter.
It matters. It gives wrong impression to court.
So I am for the appeal, your Lordship. So records of the year, the old record in the case is of the year, original case 80 to 83.
We'll issue why the records are not coming. From where it will come.
So reminder may be issued, your Lordship, with urgency, your Lordship.
What was called for died order dated 29/4.
Heard Mr. S. Ali, learned counsel for the appellant. Also heard Ms. A. Gayan, learned central government counsel. It appears from the office note dated 18/7/2026 that the trial court records have not yet been received. The registry shall issue reminder or requisitioning the trial court records. List this matter.
So date may be fixed, your Lordship.
Date fixed for second week of August. 11th of August.
My lord, inadvertently, my lord, we have not taken steps on respond number 2, so some time may be needed. my lord.
Heard Ms. L. Sharma, learned counsel for
This case is there. Is pending for consideration today.
L. Sharma, learned counsel for the appellant. Also heard Mr. M. Talukdar, appearing for respondent number
One was.
1. Learned counsel for the appellant has submitted that due to some communication gap, the appellant could not take steps for issuance of notice upon respondent number 2. How many respondents are there?
Only 2, my lord.
2. And seeks some more time for doing so. The prayer is allowed. The appellant shall take steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 31st of August. ISO.
It may be heard, my lord, at the time of completion of service, my lord.
I is for
For stay, my lord.
Stay. Date fixed for consideration. Hearing of the matter.
no, but
No problem. my
we are not granting stay.
Now see.
We are not granting stay. We are directing issuance of notice.
lord. Conclusion may have-
I heard Ms. L. Sharma, learned counsel for the applicant. Also heard Mr. M. Talukdar, learned counsel for respondent claimant. Issue notice to the opposite party number 2. The applicant shall take steps for issuance of notice upon opposite party number 2 by speed post as well as by usual mode within 7 days, returnable on 31st of August.
Obliged me.
May I please, Lordship? There is an application for condonation of delay of 129 days in filing the connected land acquisition appeal, Lordship. Earlier, respondent sides took several
adjournment.
Mr. Gogoi, have you filed?
Lordship,
They did not file.
yet to be file objection, we want to file objection, Lordship.
This is a 129 days only, so it's not in, this is not an inordinate delay. And we have explained the delay.
How much time you require?
2 weeks time, Lordship.
Last chance then.
Okay. Heard Mr. S.D. Purkas, the learned counsel for the applicant. Also heard Mr. T.R. Gogoi,
Lordship.
learned government counsel, who seeks one more chance to file written objections in this matter. The prayer is allowed. Let this matter be discussed. Agodhya, before 15th, 12th of August.
It may be last chance, Lordship, fourth time. I think 11 also will be the same order. They will sixth time, same. Only case numbers are different. Like it's
11 also delay condonation.
delay condonation. That is
Same
130
order,
days.
same order.
Blessed. My lord, may I kindly see the order passed in IA number 168024.
Which order?
It is passed on IA civil number 168024 and order dated 9/19 19/6/2026.
Indian Succession Act on the
Last order. But before that, my lord, I invite your lordship to kindly see the order dated order passed in IA number 1591. 1591 paste order dated
1591 some.
IA similar 1591. Order dated 29/5/24. So this order has created some confusion. So many IS have been filed to withdraw the main case. Now the main case has been restored. What should I say? Now the main case has been restored. On the other hand, the testamentary appellant has died, leaving some legal heirs. So I may be allowed, as the main testamentary appeal has been restored, so I may be allowed to withdraw this testamentary appeal and to file administrative petition before the court below with condonation petition, because due to this order of the Honorable Court, this has created some confusion. So now that is over.
This 1680 is for
My lord,
testamentary appeal 3 some.
the several cases were filed, one for substitution of legal heirs, another for restoration of the main case, because that was dismissed due to misunderstanding. So now simple our submission will be, my lord, as the testamentary appeal has been restored. So we may be allowed to withdraw the testamentary appeal, granting liberty to file administrative petition before the appropriate court below.
In main appeal, testamentary appeal, heard Mr. M.U. Mahmood, the learned counsel for the appellant. Also heard Mr. Yes,
C. Sharma, Lord.
C. Sharma appearing for
5, 7, 8, 9, and 10.
appearing for respondent number 5, 7, 8, 9, and 10. Also heard Mr. B.J. Mukherjee appearing for respondent number 6. It is submitted by learned counsel for the appellant that during the pendency of this appeal, the appellant has
Right.
died. The appellant was you are the executor of the will.
He was the executor. Now we will file administrative petition before the court below. As
Who
separate cause of
was
action as arose.
the executor in the impugned will. Learned counsel for the appellant submits that due to the death of the appellant who was the executor of the will, the
Probate.
appellant, the requirement of filing appropriate application for issuance of letters of administration before the appropriate court is there, and as such, he prays for allowing this testamentary appeal to be withdrawn. The prayer is not objected to by the respondent's learned counsel for the respondent. Hence, in view of submission made by the learned counsel for the appellant, this appeal is dismissed with liberty to approach appropriate court for filing application for grant of letters of administration is allowed.
I'll do one prayer. Because this due to misunderstanding of this order, there is some delay. So if we file a condemnation petition, that may be considered by the natural leniency.
No,
No, my lord, actually,
section
kindly consider.
Section 14 or Article 14 of Limitation Act will help you.
No, my lord, this is because
Limitation.
due to this order, so there is delay. So it was dismissed due to misunderstanding. So then it was restored. All these reasons, more than 90 days have already over. So if we file a condemnation petition, that may be liberally considered.
No, that you have to pray before the appropriate court. While considering any prayer for condonation of delay filed in case of filing of an application for issuance of letters of administration, the court before which such application is filed shall take into consideration the pendency of this appeal and take into consideration the period of pendency of this appeal before this court while deciding as to whether any benefit can be given to the applicant under Section 14 of the Limitation Act or not. With this observation, this testamentary appeal is disposed of.
Obliged.
Connected eyes are closed in view of the orders passed in testamentary. All connected eyes.
Benefit would be given or not, that is up to that court.
You would take recourse to section 14.
Yes. Definitely we'll take, but delay is due to that order, my lord.
That I have reflected.
All highly obliged.
That means your lordship. Lordship, as a record has been called for, can you pass out for a finding lordship? Record has been called for, requisition has been made.
The IA that I have filed, your lordship, and they have filed that of, I sent the IA.
Right. Now, of this, it has not been received yet, lordship, as per my information.
No, I,
It is
upon
on the track of-
requisition, yeah, recently.
Yes, we have filed it.
Okay, let it come.
After some
Let it
time, your
come
lordship.
after some
let it-
time.
Okay.
It replies.
Obliged.
Otherwise, today the date was fixed for filing written gist.
Lordship.
I have brought the written argument, your lordship.
Lordship,
Oh.
as Mr. Renalam is also, he's also late, lordship.
Okay, we'll take it up after some
Sir.
time.
After some time, your lordship.
None has appeared. Yes, Mr. G. Goswami, you are there in this.
I'm extremely sorry, my lord. My lord, actually, I'm praying for some time, my lord, in this matter, my lord.
Heard Mr. G. Goswami, learned counsel for the appellant who prays for an adjournment due to some personal difficulty. The prayer is allowed. Let this, none has appeared for the respondent on call. Mr. U. Mr. A. Dev, learned counsel for respondent, does not raise any objection. Hence, the prayer is allowed. Let this matter be listed after 4 weeks on a date to be fixed by registrar.
Super short date is be given because it is a long pending matter.
Short dates are not available.
Okay, your lord.
4 weeks.
Much of.
Keep it. Yes.
May it pleases your lordship. I'll have to go, lordship, I'll read the judgment so that I can mention about my grounds, lordship. We are in fact alleging fraud in this case, lordship. Among other grounds.
Okay.
Lordship, the other grounds, I'll just briefly say income was taken as 35,000 on the face and oral yield. And then we have acquired through RTI the income. There was no loss of income because he was working, lordship. And lordship, in fact, there was no accident.
No accident.
No accident. I'll show lordship. That is why we are alleging fraud. Maybe he fell down. I'll show from document that he fell down. And lordship, most of that the court has come to amount of medical expenses for 3,76,000. All the documents are photocopies. Because lordship, he has in fact reimbursed maybe from his office. And then he has filed this duplicate and photocopies in the lordship. I'll show all the documents from the LCR, lordship.
Yes.
Can I start reading, lordship?
Yes, yes.
Judgment starts at page 7 of my memo of appeal. The actual judgment at 8, lordship, next page. The proceeding under Section 166 of MB Act 1988 is initiated by the appellant Sri Dipen Chandra Das, son of late Bapuram Das of village Chataguri, PS Morigaon, District Morigaon, Assam, who has applied for grant of compensation of rupees 30 lakhs on account of injuries sustained by him in a motor vehicle accident that occurred on 24/11/2014 at about 12 noon on National Highway in front of main entrance gate, Nagaon Paper Mill, Jagi Road, under Jagi Road Police Station in the district of Morigaon. It is stated that on the fateful day, that is on 24/11/2014 at about 12 noon, he was going from Jagi Road towards his house by riding a motorcycle bearing registration number so-and-so as pillion with one Jogeram Taru, and on reaching in front of main entrance gate of Nagaon Paper Mill, Jagi Road, the offending vehicle bearing registration number so-and-so Indigo car coming from the same direction in a very high speed had hit his motorcycle from the backside. As a result of the accident, the claimant and the rider of the motorcycle, namely Jogeram Taru, fell down on the road. The claimant sustained grievous injuries on different parts of his body. Immediately, both of them were admitted at Nagaon Paper Mill Hospital, from where the claimant was referred to Pratiksha Hospital, Gauhati, considering his seriousness. Lordship, this immediately they were admitted at Nagaon Paper Mill. There is no document to show this, Lordship. Claimant was referred to Pratiksha Hospital, Gauhati, considering his seriousness. It is stated that the accident took place due to rash and negligence on the part of the driver of the vehicle bearing number so-and-so Indigo car. The claimant was 55 years of age at the time of accident. It is stated that the claimant is an employee of Nagaon Paper Mill and he used to draw salary of rupees 35,000 per month. This will be important, Lordship. Later on, I'll cover that. With regard to the accident, a case was registered at Jagi Road Police Station by Jagi Road PS case number 1 of 2015. It is this also, Lordship, I'll cover later on, this Jagi Road PS case. It is stated that the offending vehicle bearing registration number so-and-so Indigo car was insured by OP1 Oriental Insurance Company Limited by policy number so-and-so, valid up to 10/9/2015. OP number 2, Srijut Shamal Kanti Saha, was the owner of the said offending vehicle, and at the time of accident, OP number 3, Srijut Dipen Kolita, was driving the vehicle, said vehicle, who had a valid and effective driving license under driving DL number so-and-so, valid up to 27/3/27. On receipt of notice, OP number 1, Oriental Insurance Company Limited, has filed a written statement after entering their appearance. The opposite party number 1, owner of the offending vehicle, and opposite party number 3, driver of the offending vehicle, have submitted a joint written statement. However, they did not contest the case further after submission of their written statement. Hence, the insurance company is granted leave under Section 170 of the Motor Vehicle Act to defend its case on all available grounds that remain open to other opposite parties. The opposite party number 1, Oriental Insurance Company Limited, in their written statement has taken the usual legal pleas and submitted that there is no cause of action for the claim and the same is not maintainable under the provision of MB Act. It is also pleaded that the claim petition is bad for misjoinder and non-joinder of necessary party. It has also questioned the age, occupation, and income of the claimant and termed the compensation amount as highly excessive and exaggerated without any basis. The opposite party number 1 has also raised question on the date, time, and place of accident. This, Lordship, I'll cover this also later on, as well as the jurisdiction of the police station who registered the case with regard to the accident. The insurance company has further denied all other averments made in the claim petition and pleaded that claimant is to be put in strict proof of his claim. The opposite party number 2, owner of the offending vehicle, and opposite part OP number 3, driver of the offending vehicle, stated in the written statement that there is no cause of action for the claim and the same is not maintainable in its present form and manner. The claim petition is also hit by the principle of waiver, equins, and estoppels. It is pleaded that the accident took place due to negligence of the claimant himself. It is stated that if the claimant is liable to get any compensation, then the insurance company, that is OP number 1, Oriental Insurance Company Limited, is liable for the same as at the relevant time of accident, the offending vehicle bearing registration number so and so Indigo car was duly insured with the said insurance company, while policy number so and so, which was valid up to 10/9/15. And on the time of at the time of accident, the driver, that is OP number 3, Srijut Dipen Kolita, also had valid and effective driving license under DL number so and so, valid up to 27/3/2027. In support of their contention, the photocopies of the registration certificate of vehicle, driving license of driver, insurance policy are furnished with their written statement. Consequent upon the pleading, the following issues are settled for determination. Whether the accident took place on 24/11/2014 at about 12 noon on National Highway in front of main entrance gate Nagaon Paper Mill, Jagi Road, under Jagi Road Police Station in the district of Morigao, due to rash and negligence on the part of the driver of the vehicle bearing number so and so Indigo car. Whether the claimant sustained injury as a result of motor vehicle accident that took place on 24/11/2014 at about 12 noon on National Highway in front of main entrance gate Nagaon Paper Mill, Jagi Road, under Jagi Road Police Station in the district of Morigao. This issue, Lordship, I'll be arguing on. Whether the claimant is entitled to get any compensation, and if so, by whom it is payable and to what extent. The claimant injured has examined himself as PW1, and certain documents were also brought on record by him. Apart from that, one independent eyewitness of the accident and a medical officer are also examined as PW2 and PW3 respectively. No rebuttal evidence was led by from the side of the opposite party number 1, Oriental Insurance Company Limited. I have heard learned counsel for both sides, considered the evidence on record, and come to the following decision. Discussion, decision, and reasons for decision. All the issues are inseparable in nature and interrelated, so they are taken together for discussion for the sake of brevity and convenience. PW1 claimant in his affidavit evidence in affidavit has supported his case on all fronts. According to him, on the fateful day, that is on 24/11/2014, Lordship, this date will be very vital, date of accident, Lordship. At about 12 noon, he was going from Jagi Road to his working place by riding a motorcycle bearing registration number so and so as pillion, and while waiting by the side of the divider of the National Highway to reach the service road in front of the main entrance gate of Nagaon Paper Mill, Jagi Road, the offending vehicle bearing registration number so and so Indigo car came from the same direction in a very high speed and hit his motorcycle. As a result of accident, the claimant and the rider of the motorcycle, namely Jogeram Taru, fell down on the road and he sustained grievous injuries on different parts of his body. Immediately, he was admitted at Nagaon Paper Mill Hospital, wherefrom he was referred to the Pratiksha Hospital, Gauhati, considering his seriousness. It is stated that the accident took place due to rash and negligence on the part of the driver of the vehicle bearing registration number so and so Indigo car. The claimant has stated in his evidence in affidavit that he was 55 years of age at the time of accident and he was an employee of Nagaon Paper Mill. After the accident, he had become completely bedridden. Lordship, this I'm challenging. Completely bedridden for more than 5 months, and during that period, no salary was paid by his employer, as he was unable to join in his service. He had undergone 2 major operations and incurred more than rupees 8 lakh during his treatment. Claimant number PW1 claimant has further stated that he has applied for the voluntary retirement from his service since he was unable to perform his official duty properly, and for the said purpose he has submitted most of the medical document and voucher before the concerned authority. Lordship, this whole paragraph he has become disabled to the extent of 50%, which was assessed by the medical board. With regard to the accident, his son lodged a complaint before the Jagi Road. This, Lordship, this also I will be covering in my argument. His son lodged a complaint before the Jagi Road police station against the driver of the offending vehicle, which was registered by Jagi Road PS case number 1 of 2015 under section so-and-so IPC. During cross-examination by the insurance company, PW1 has asserted that the accident took place near the medical gate of HPC paper mill while he was coming by a motorcycle as pillion. The offending vehicle hit his motorcycle from behind. At the relevant time of accident, the owner of the motorcycle named Srijut Jogiram Taru himself was riding the motorcycle. He was immediately admitted at the paper mill hospital, from where he was referred to Gauhati for better treatment. He was treated at Pratiksha Hospital at Gauhati for 7 days. Lordship will this is 7 days, that is from 24/11/2014 to 30/11/2014. Thereafter, he was again admitted in the said hospital on 5/12/2014 to undergo operation in the spinal cord and took bed rest for 3 months. Lordship, this is very vital. He took treatment for spinal cord and took bed rest for 3 months as per doctor's suggestion. After taking rest for 3 months, he joined his duty. This Lordship will mark, because this is an injury case. Disability compensation is given, but it is his own admission in cross that he joined his duty. A plate was fitted near the spinal cord. He has denied the suggestion put by the insurance company that he did not submit proper documents along with his affidavit. He has also denied the suggestion that he has submitted the original documents of expenses before his authority for reimbursement, which he has already received from the department. He has admitted that he did not mention his monthly income in his affidavit, and he also did not submit the salary certificate along with his affidavit. Cross-examination wholly is very relevant in this case, Lordship. He further denied the suggestion that the accident did not take place due to rash and negligence of the offending vehicle. Rather, the accident took place due to fault of the rider of the motorcycle. He also denied the suggestion the medical documents which he has submitted are not proper, and he is not entitled to get compensation from the insurance company. By examining himself, PW1 claimant has brought on record the following documents. Exhibit 1, the accident information report. Exhibit 2, certified copy of FIR, Ezahar and seizure list. Seizure list I'll be arguing on, Lordship. Exhibit 3, charge sheet. Exhibit 4, the injury certificate, Lordship. I'll be arguing on that also. Exhibit 4. Then, Lordship, referral form issued by HPC Limited Hospital, Nagaon Paper Mill. This is photocopy, Lordship. Then Exhibit 6 and 7 are discharge certificate. I'll be arguing on them, Lordship. 6 and 7, page 81 and 82. Doctor's opinion regarding disability, Exhibit 8, Lordship. Then medical reports and prescription, then medical vouchers. Lordship, all these are Exhibit 9 series and Exhibit 10 series are all photocopies. All photocopies, because he was working, he has submitted, and that was brought in cross-examination, though he has denied that. Then, Lordship, Exhibit 11, disability certificate. I will be challenging this disability certificate also. Exhibit 12, X-ray report. PW2 Srijut Uddhav Medhi stated in his evidence in affidavit that he knows the claimant injured who sustained injuries in a motor vehicle accident that took place on 24/11/2014 at about 11 a.m. on National Highway in front of the main entrance gate of HPC Limited, Jagi Road. He has stated that at the relevant point of time, while he was standing on the roadside of the National Highway in front of the main entrance gate of HPC Limited, Jagi Road, he saw that the vehicle bearing registration number so-and-so Indigo car coming from the Gauhati side at a very high speed had hit the motorcycle bearing registration number so-and-so, which was standing by the side of the National Highway to reach the service road. He also saw that the claimant injured was sitting in the motorcycle as pillion. Immediately, he, along with other people, rushed to the spot and brought the injured person to the HPC hospital with the help of police. He has further stated that the accident took place due to fault of the vehicle bearing registration number so-and-so Indigo car, which was driven by at a very high speed. He also saw that the claimant sustained grievous injuries and was referred to Gauhati due to critical condition. Police recorded his statement in connection with the said accident. Lordship, he is saying police recorded his statement in connection. This I am challenging because, Lordship, there was no GD entry, no case registered. It was only when, Lordship, that exhibit petition, Lordship, I'll show, Lordship, later on, that the case was started, Lordship. There was no police report initially. During cross-examination, PW2 asserted that on the day of occurrence of accident at the relevant time, he was standing on the roadside of National Highway and waiting for a bus. He saw that the accident took place while the motorcycle was waiting by the side of the divider of National Highway to cross the road. He has stated that the claimant was riding the motorcycle as pillion. At the time of accident, some other people were also present at the roadside. Immediately after the accident, the injured person was taken to the nearest hospital. He has denied the suggestion put by the insurance company that he did not see the occurrence of accident. He has also denied the suggestion that the Indigo vehicle was not involved in the said accident and the accident took place due to fault of the rider of the motorcycle. PW3, the medical officer, Dr. A.K. Fukan, deposed in his evidence in affidavit that on 29/9/2015, he was serving at Morigao Civil Hospital as SDM and HO, and on that day, a medical board was constituted by the District Social Welfare Office Morigao, in which he was one of the members. On that day, he examined the injured, Sri Dipen Chandra Das. During medical examination of the injured, he found that the injured sustained grievous injuries and there was shortening, and Lordship will mind this, there was shortening and deformed both legs following multiple fracture of lower limbs due to road traffic accident. Lordship, this I'm going to show by document that this, why I said that he was not injured. This injury was not in that accident of 24/11, Lordship. PW3 opined that the degree and percentage of permanent disability of the injured is 50%. He has also opined that the injured will not be able to do any hard work due to his injuries. He has exhibited the disability certificate issued by the issued to the claimant by Exhibit 11, wherein Exhibit 11.1 is his signature. During cross-examination, PW3 asserted that permanent disability of the injured person was assessed at 50% due to shortening and deformed of both legs, this Lordship, both legs, with multiple fractures due to the road traffic accident. He also stated that before issuing the disability certificate, he had clinically examined the injured and found that there is hardly any chance of recovery from his disability. The evidence of PW1 claimant and PW2, as well as the evidence of PW3, coupled with the exhibited documents, particularly the Exhibit 1 Accident Information Report and Exhibit 2 certified copies of FIR, Ejahar, and Caesar list, and Exhibit 3 this charge sheet were submitted to were subjected to critical analysis, and it stands abundantly established that on 24/11/2011, at about 12 noon, a motor vehicular accident took place on National Highway in front of main entrance gate, Nagaon Paper Mill, Jagi Road, under Jagi Road Police Station in the district of Morigao, involving the aforementioned vehicle bearing registration number so-and-so Indigo car having insurance coverage with opposite party number 1, Oriental Insurance Company Limited, while a valid insurance policy bearing number so-and-so, which was valid up to 10/9/2015. The said vehicle was owned by OP number 2, Srijut Shyamal Kanti Saha, and at the time of accident, one Sri Dipen Kolita was driving the vehicle, which had a valid and effective driving license. As a result of the said accident, the claimant has sustained multiple injuries, and a case was also registered at Jagi Road Police Station by Jagi Road PS case number so-and-so under section so-and-so, and after investigation, charge sheet was filed against the driver of the offending vehicle. The claimant has stated that at the time of accident, he was 55 years of age. He also stated that he was an employee of Nagaon Paper Mill, Jagi Road, and he used to draw a salary of rupees 35,000 per month. Lordship, this I am going to challenge, this salary of 35,000 per month. However, he has not furnished any document with regard to his monthly salary, which has also admitted during his cross-examination by the insurance company. It is seen that the insurance company has not raised any question with regard to the monthly income of the Lordship. The sentence before is showing that we have challenged that he has not given any. The next sentence, Lordship, the court is saying that the insurance company has not raised any question with regard to the monthly income of the claimant. The insurance company has not even put any suggestion in this regard. This is totally wrong. Therefore, it can be presumed that there is no dispute with regard to the income of the claimant. From the evidence on record, it is established that the claimant suffered bodily injuries as a result of the said accident, for which he became permanently disabled to the extent of 50%, and it will be definitely affecting his earning capacity. Therefore, the loss of income for permanent disability to the extent of 50%, which is proved by the medical officer, is assessed by this tribunal at rupees 35,000 into 12 such multiplied 23 lakhs 10,000. In view of the above, this court is of the view that the claimant is entitled to loss of income. Lordship, first of all, let me show Lordship why we are challenging this loss of income. We have also filed an application under Order 41 Rule 27, Lordship, because after the judgment was passed, because the court has, we had challenged the and the court has
Putul, aye.
I-3783. Court had taken the income of 35,000 Lordship without any document. So we applied to HPC Lordship for the to show his income. There is no loss. And in fact, in the that Lordship will find in our appeal memo also, we have annexed these documents, Lordship.
No, what happened to this order 41 rule 27?
It is still pending, Lordship.
You have to argue on that also.
Yes, I'm arguing. That's why I'm arguing on that, Lordship. Because since we are challenging on this, I'm going to show Lordship judgment of our own High Court when Order 41, it was because Lordship, what Order 41 says, Lordship, that due diligence. After passing of the judgment, we have received this document which shows that there is no loss. Lordship will find at page.
Which document?
Lordship, page Annex 5, page 20
Of
the IA. I'll fully argue on this also, Lordship, but I'm just showing. Because on loss of income, I'll have other.
what is this?
This is his income, Lordship, payslip for November 2014. Why he did not exhibit the payslip, Lordship? It is because of this. That in his evidence, he said that he doesn't have any income. But Lordship, and moreover, there is a note. Due to accident, his attendance during the month of December 2014 was less than 10 days, and therefore, payslip for that month has been generated through system, which was ultimately adjusted during March 2015. That means even till March 15, he was getting his salary, Lordship.
How much salary?
As per this, Lordship, net pay was 9,430 in November.
Because he could not attend the office.
That period will be okay, only that period, but there cannot be a loss of income. Lordship, I'll show Rajkumar, Ajay Kumar, that disability itself is not loss of income. Disability.
By showing this document, what you want to say?
That the income court has taken as 35,000, loss as 35,000 is not correct.
He got 9,000 has to be deducted.
Lordship?
9,000 has to be deducted therefrom.
No. There is no loss, Lordship.
No.
The court has calculated loss of income by using multiplier.
By taking his earning at rupees 35,000.
Huh.
Your submission is that in November he got 9,000 salary.
Yes. 9,430.
So
no.
Loss of income is not to the extent of 35,000, but to the extent of 35,000 minus 9.
No, he was never getting 35,000, Lordship. I'll come to that. He was not getting 35,000.
No, have you cross-examined him on that?
Yes, I'll show that
Sure.
also. That's why that's why the court has also mentioned that we have cross-examined. Lordship, he should have given his, if he lost his salary, if he lost his he should give his proper. Why I said fraud, Lordship? Because he has hidden certain facts from the court. And the court has straightway come to the finding that.
No. Before you make your submission on this. Which document you want to Bring on record by filing order 41 rule 27 application.
The documents that I want to bring on record, Lordship, are Lordship, this is a Pratiksha Hospital bill, Annexure 1, page 8, Lordship. That he
Let us see your prayer in order 41 rule 27 application.
It is therefore prayed that your Lordship would most graciously be pleased to admit this application and would further be pleased to allow the applicant company to adduce evidence in the case by placing on record the hospital report given by Medical Superintendent Pratiksha Hospital, Gauhati, the RTI reply given by Officer in Charge Jagirod PS along with GDE number 687 and 692 dated 24/11/2014 and the pay
Because
statement.
if this petition is allowed, the matter has to be remanded back,
Yes, Lord.
or if it is allowed.
Yes. I have one order of our High Court Lordship in MSc Appeal 84 of 2017 Lordship, though I have printed it in rough paper Lordship. When we had, because this was Lordship regarding false policy, then Lordship Mir Alfaz Ali had ordered that the case will be pending here and had sent the records, trial court record to the trial court, and it allowed the insurance company as well as the claimant to adduce their evidence.
No, that is the procedure. If order 41 rule 27 application is allowed, that has to be done. But you have to convince this court that there is a case under 41 rule 27.
That Lordship I'll do from this in the appeal itself, Lordship. The documents they have given, Lordship, the proof that he was admitted in the hospital, Pratiksha Hospital in June.
Not from that. When you can adduce evidence?
Lordship?
Order 41 rule 27 lays down certain criteria.
Yes.
Whether you fulfill those criteria.
Yes, Lordship. I
That
do.
you have to say.
Yes, I do, Lordship. Because, Lordship, his own document will show, Lordship, that the first document, Annexure 1 that we have given, Lordship, is that he was admitted in Pratiksha Hospital for his leg injury, Lordship, in the month of June itself. And his disability is related to that only. Not to, and the accident also I'll show from the record that there was a fall, not an accident.
Okay. Then what prevented you from producing these
Because
documents?
we did not have these documents at that point of time.
When it came to your notice?
Later on.
When?
At least the dates are there, Lordship. 21/11/17.
During the pendency of the.
Just a minute, Lordship. This document was with us during pendency, Lordship, the first Annexure 1. Annexure 2 also with us, but the income, Lordship, was after. DD entries were for the page 17, Annexure 3, Lordship. This was after passing of the judgment, the investigator was.
No, you have to satisfy that you could not have produced these documents before the tribunal in spite of your due diligence.
Yes.
That you
Yes, Lordship.
That you have to satisfy.
Yes, Lordship. Lordship, first of all, let me read Order 41, Rule 27.
Yes.
Production of additional evidence in appellate court. The parties to an appeal shall not be entitled to produce additional evidence, whether oral or documentary, in the appellate court. But if the court from whose decree the appeal is preferred has refused to admit evidence which
it is not applicable
to us, the party seeking to produce additional evidence establishes that notwithstanding the exercise of due diligence, such evidence was not within his knowledge or could not, it was not within our knowledge or could not from after the exercise of due diligence be produced by him at the time when the decree appeal against was passed.
Yes, this you
And
have,
Your Lordship, the appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment or for any substantial cause. These two, Lordship, I am praying against these two.
you
Substantial
satisfy this.
Yes, Lordship. This annexure 3, page 17, Lordship. It,
You satisfy that in exercise of due diligence, you could not have produced it before.
Lordship, in any MSc cases, who proves the income, Lordship? The claimant has to prove. If it is a death case, the age and in this kind of disability cases also, who has they failed to prove it
Yeah.
because they wanted to misrepresent before the court. Had they produced this document, then what would have happened, Lordship? That the court would have said that he is getting his salary. There will not be any.
This is not the question. While deciding order 41 rule 27 produced,
Yes.
whether they failed or not, that is not the question.
But then
Question.
the intention.
No,
If they had done it with
listen to my query carefully.
Yes.
You have to establish that in spite of due diligence, you could not have produced it.
Yes, Lordship, because Lordship, in spite of due diligence, Lordship, because it is their income. When the judgment came, the insurance company found that the amount which was spoken by the person, the claimant, was accepted in toto by the tribunal. Whereas I'll show from the cross-examination, Lordship, because if these documents are not even allowed, Lordship, if suppose Lordship finds that there was no due diligence, from other documents which are part of the record, I'll show that there was fraud, Lordship.
No, that is another aspect.
So if there is fraud, Lordship, any court, any tribunal can exercise its jurisdiction, Lordship. That is what will be my submission here. Because they have tried to misrepresent 35,000, he has said, that is total misrepresentation, Lordship. So every court, if necessary, I can give the judgments also, Lordship, on that point, that any court or tribunal has the right, if we show that there was suppression of material facts by the claimant.
No, because while passing judgment, this court has to first decide your order 41 rule
Correct, correct,
27.
Lordship. Correct,
Either it has to allow or disallow.
correct.
Therefore, I was asking for your submission on order.
My submission is that, Lordship, when fraud has been committed on the court, then, Lordship, any court or tribunal has the power to interfere with the judgment, Lordship, not judgment. Any court or tribunal has the power to allow the petition, Lordship. This, Lordship, I'll give Rajendra Kumar, as well as, Lordship, this, in fact, I'm not. And I'm sorry, Lordship, this copy, Lordship, is rough copy is there, but I'm submitting, Lordship, at para 2, Lordship.
This Rajendra Kumar,
Yes,
this judgment.
yes, Lordship.
Yes.
Lordship, B. Or Lordship, I'll go to para 4, Lordship. For a High Court in India to say that it has no power even to consider the contention that the awards secured are the byproducts of stark fraud played on a tribunal, the plenary power conferred on the High Court by the Constitution may become a mirage, and people's faith in the efficacy of the High Courts would corrode. We would have appreciated if the tribunal or at least the High Court had considered the plea and found them unsustainable on merit, if they are meritless. But when the courts preempt the insurance company by slamming the door against them, this court has to step in and salvage the situation. Then, Lordship, paragraph 12. Because in between, that is the facts of that case, Lordship. What happened in that case was that those people were not even injured in the accident. Like in our case, Lordship, they were not even injured. They got the compensation. And after payment of the compensation, the insurance company came to know that fraud has been played on them, and they filed petition before the tribunal. Tribunal rejected it. High Court rejected it. Ultimately, Apex Court allowed it, said that no tribunal or High Court, every tribunal or High Court or any court has power to adjudicate a matter, Lordship. Because
No, this is not a question of not adjudicating. The judgment which you have shown pertains to a writ petition. That is
no, basically it was MEC case, Lordship. I'll read then the full
maybe.
judgment.
The question was whether the question of fraud can be adjudicated in a writ petition or not.
Huh.
This Apex Court held that court has that power.
Yes.
But before this court, the first issue is whether your Order 41 Rule 27 application
That is,
is
that's why I'm saying, because there is a fraud, there is misrepresentation. That is why the petition is to be allowed. That is why I'm giving our own High Court order, Lordship, in MSC Appeal 84 of 17, wherein, Lordship, this is okay. Final judgment also we have one. I was there, Lordship, and here, Lordship, though I'm sorry for the page, Lordship, rough page it is printed, paragraph 2, Lordship, where I had submitted that there is fraud practiced. There was a policy, which policy was the owner said that that policy was there. I submitted in the High Court, Lordship. We did not use any evidence before the trial court. In the High Court, I said that the policy is false, and they have taken advantage, and by misrepresentation, then the court allowed this interim order, Lordship, in the MSC appeal. The case was sent back, evidence was allowed to be, and both the parties were given opportunity.
So what is the law? Law is insurance company will allege fraud in every case.
No. We do not, Lordship. Every day I'm doing cases. Where are we alleging fraud?
We are deciding Order 47 Rule, Order 41 Rule 27 petition
Yes.
first.
Yes.
You have to satisfy this court that you have a case for allowing you to adduce additional evidence. And to do so, you have to convince this court that in spite of due diligence, you could not have produced the documents which you are seeking to produce now at appellate stage. This much we have to decide.
Yes.
Your submission is that
Other documents, Lordship, other documents, I understand that they were beforehand. The police report, the GD entry, and the
because in this case, the insurance company did not adduce any evidence.
correct.
In spite they were given chance.
In that Lokhidas also, we did not adduce any evidence.
So no, is this the law that when you were given chance before the tribunal to adduce evidence, you did not adduce evidence, and later on you allege fraud, and
in Rajender Singh case also, Lordship, insurance company did not adduce evidence. Insurance company paid the amount. Later on, someone informed the insurance company that the son and father duo had not were not involved in any accident. Then they approached the court, Lordship,
alleging fraud.
alleging fraud. And then the court allowed that. Apex Court allowed. Even in High Court, they lost.
But this is not such a case. Here you have filed an appeal.
And that is why Order 40.
In the memo of appeal, have you alleged fraud?
Yes.
Which ground?
And these documents also I have annexed, Lordship, in the memo of appeal.
No, that is not my question.
Yes, B, Lordship. For fraud which is all action in a judgment obtained by fraud is non-est and is liable to be set aside. Thus, the judgment deserves to be set aside. Before that, my grounds, Lordship, are on the RTI reply and Pratiksha Hospital report.
Which ground?
D, Lordship.
No,
Because Lordship,
this is
C,
still,
B, A, B, C, Lordship, in fact, goes to proof D. From their document, if Lordship will not allow my order 41 petition also, then also this appeal is to be allowed, Lordship, because I'll show from their documents that he was injured beforehand in the month of June.
okay.
These are correlated, Lordship, that I'm bringing.
So is it your submission that since you have alleged fraud, order 47 rule, order 41 rule 27 petition is to be allowed?
Yes. That is my
Okay.
submission.
Okay, your next submission.
Lordship, now, on the judgment, on loss of income, Lordship. First part, court has given 23 lakhs, 10,000 by the income. Where is the income proof, Lordship? Lordship might reject my order 41 petition. There is no income proof. How the court came to a loss that he was earning 35,000 per month and that there was a loss. Because of that, Lordship, let me take Lordship to their evidence, cross-examination. Lordship will find evidence on affidavit of PW1 at page 36 to 40, cross-examination at page 41
Of the,
of the LCR.
yes. What you want to show?
I'll go directly, or
Okay.
should I read the whole evidence?
No, you come to directly to the
That,
point.
yes, Lordship. In middle, Lordship,
Page number?
page, that is page number cross-examination, PW 41, Lordship.
Yes. Yes.
I was admitted, Lordship will get 1, 2, 3, 4, 5, 6, 7th line. I was admitted at Pratiksha Hospital from 24/11/2014 to 30/11/2014. I was again admitted in the same hospital on 15/12/2014 to undergo operation. An operation was conducted in the spinal cord. Lordship will mind this, spinal cord, because I will relate this to the disability certificate for which 23 lakhs has been given. Spinal cord, his injury was on this date in the month of November, his injury was on the spinal cord. Thereafter, I took bed rest for 3 months as per doctor's suggestion. After taking rest for 3 months, I again joined my duty. Rajkumar Ajay Kumar comes to my help here, Lordship, because if he again joined his duty, where is the loss, Lordship? Maybe the loss is for 2 months, 3 months, whatever months, Lordship. That also I will show that there was no loss. But
No, the evidence says that due to injury, he had to take voluntary retirement.
where is that document, Lordship? Just I say that I am President of India. Do I become President of
But
India?
you have option to cross-examine that
That
you
was
are.
cross-exam. That's why otherwise I can read.
You show that you have demolished his oral evidence in your cross-examination.
Yes, I can read the whole cross, Lordship.
Yes.
The accident took place near the medical gate of HPC. Now here, Lordship, he is coming to the medical gate of HPC, paper mill. Otherwise, it was the main gate. I was coming by a motorcycle. I was sitting as pillar. Our motorcycle was hit by the offending vehicle from behind. Our motorcycle was driven by Jugeram Taro, who was the owner of the motorcycle. I could not remember the registration number of the offending vehicle. I was immediately admitted to the paper mill hospital. There is no document of admission in paper mill hospital just after the accident. I was referred to Gauhati for better treatment immediately. I was treated at Pratiksha Hospital at Gauhati. I got treatment at Pratiksha Hospital for 7 days, Lordship. These dates and these 3 months, 5 months, I'll show from the documents, Lordship, that how many days he had taken treatment. 7 days. I was admitted at Pratiksha Hospital on 27/11/2014 to 30/11/2014. So 7 days are there, Lordship. I was again admitted in the same hospital on 15/12/2014 to undergo operation. An operation was conducted in the spinal cord. Lordship, this I am giving importance because I'll come to page number 81 and 82 later on, Lordship, to show what was the treatment taken. It was spinal cord. Thereafter, I took bed rest for 3 months as per doctor's suggestion. After taking rest for 3 months, I again joined my duty. This is coming in cross-examination, Lordship. So if he again joined duty, where is the question of voluntary retirement?
No, in his examination in chief, he has stated that he took voluntary retirement. On that, whether you cross-examine.
I'll read rest of the. I rest for 3 months as. Thereafter, I took bed rest for 3 months as per doctor's suggestion. After taking rest for 3 months, I again joined my duty. A plate is, Lordship, this, I feel this covers, although I'll read this itself covers that where is his voluntary retirement? He joined his service.
No, joining service does not mean that after joining, he may.
Who has to prove that, Lordship?
He has stated.
He has stated, but he has to prove that he has given this document for VRS, Lordship.
My query is when oral evidence, whether oral evidence has got some value or no value at all.
It has got value.
Value unless you demolish it by cross-examination.
Correct, Lordship.
Your submission is there.
Talking about VRS, Lordship, and naturally I'll have a document that I have given this application.
Yes,
The shifting of burden of proof will shift on the insurance company only when they have proved their case, Lordship.
So your submission is that even if the oral testimony remain
in this regard,
undemolished.
No, not undemolished.
Listen to my query first,
Yes.
then response.
Yes.
Even if oral testimony remain uncontroverted, certain facts are to be proved by adducing documentary evidence only.
Correct.
Is this your?
This as well as that it was demolished. This as well as when I'm saying that my income is 35,000, when I'm saying that I have applied for VRS, he has applied, Lordship. He has to give that document, Lordship. We have demolished it by showing that he has joined his service. There is no document and nothing on record to show that he has taken VRS. As soon as he joined, he could have said that though I joined, my VRS is pending or something like that, Lordship. And the document that we want to bring now, Lordship, will show that even in March 2015, he was getting his salary.
Okay.
So burden, Lordship, burden of Evidence Act, Lordship, burden will only shift to us when they have proved their case. Here, they have not proved their income. Here, they have not proved that he was doing anything anywhere. And they have not proved that he has applied for VRS. A plate is still remain under the back side near the spinal cord, and I am still suffering from pain. An Ezahar was lodged by my son regarding this incident. No Ezahar, Lordship, was actually they filed a case, Lordship. I'll show that from the documents, Lordship. They filed a complaint case before the CGM court. No accident report was given before that. Only after filing the CGM court case, they have. And I'll show from other documents from their own documents, Lordship, that his deformity in both the legs is related to the accident that took place in June of 2014. This is November. The case is of November.
Okay.
It is not a fact that I have submitted proper documents in my.
No, that means he suffered another accident.
Yes, yes. He suffered another accident. And his own document will show, Lordship. He suffered another accident in June. And in that accident, he had suffered that leg injury. And this was fall. I'll show from their own document. It is not a fact that I have submitted the original document of expenses before my authorities. So since the photocopies, Lordship, this was questioned. This question was put. Authority for reimbursement. It is not a fact that I have already got reimbursement of my accident from my own department. I have not mentioned my monthly income in my affidavit. He has not even mentioned. I have not submitted the salary certificate in my affidavit. I have not claimed compensation from the motorcycle owner and its insurance company. I have claimed from the offending vehicle. It is not a fact that because of knowing the fact that the motorcycle was not insured, therefore the insurance company of the motorcycle was not made party. It is not a fact that the offending vehicle was not driven.
In this case, whether any compensation has been paid?
No.
No, you have not received any amount. You have
No.
not received, okay. Yes, proceed.
Because in that Lokhi case, Lordship might have seen that in fact, we had deposited 25,000. Ultimately, the court said that amount we will not recover. Rest of the amount the owner has to pay because of the, because we proved that the policy was not there. It is not a fact the motorcycle owner was riding the motorcycle in his plate. It is not a fact that I deposed falsely in my affidavit. I could not recollect when I appeared before the medical board. One doctor, Bangshidhar Das, examined me. I could not recollect the names of the other doctor. Bangshidhar Das, Lordship, but Bangshidhar Das did not adduce any evidence. It is not a fact that voucher of ITNA are submitted falsely. That 3,76,124 given. I did not mention specifically the compensation amount in my affidavit. It is not a fact that I am not entitled to get compensation, whatever I have claimed. Then, Lordship, let's go to, because I am on that disabled, first point, Lordship, 23 lakhs. Let's go to the cross-examination of the doctor, Lordship, PW3, Ajit Kumar Fukon. That, Lordship, will find from page 48, Lordship.
Yes.
The injured person was examined in the medical board where I was also a member. In the disability certificate, I only put my signature. I found 50% disability due to the shortening, Lordship, this is vital, shortening and deformation of both legs with multiple fractures due to road traffic accident. Lordship, this is vital because what the PW1 said was that his injury was with the spine, Lordship. Here, Lordship, it is because of deformation of both legs with multiple fracture due to road traffic accident. Then, Lordship, let's come to page 81, Lordship. That page 81, Pratiksha Hospital document, Lordship, on the day of accident. Lordship got the page?
Yes.
81.
Yes.
Lordship, name,
Yes.
name at the top, Dipensandra Das, age 54. Lordship, then I'm on this part. Alleged history of fall today, around 12 p.m., Jagi Road.
Yes, he fell.
He fell
He
down.
fell from motorcycle due to accident.
It should be mentioned RTA.
No, RTA.
We can assume, Lordship. Then I'll come to page 82, Lordship.
Yes.
This is the discharge certificate of Pratiksha Lordship.
Okay, yes.
Lordship, date of admission, date of discharge, Lordship got in the middle.
Yes.
Then Lordship will come to surgical. Closed tibia nailing and fibula plating on June 2014. Because his deformity is in the legs, Lordship, this relates to his accident that took place in June 2014, the accident that took place. And not related to the accident that took place on 24/11/2014. It is his own document, Lordship. This is exhibited. Exhibit 6, both are Exhibit 6, Lordship.
Yes.
So, Lordship, if his deformity is with the legs, Lordship, because of shortening of legs, I've shown, and the disability certificate is also there. Disability certificate, same thing is written, shortening and deformed, both, that is Exhibit 41, Lordship, at page 116, both following multiple fracture of lower limb due to RTA. And in Pratiksha, the ye was taken, diagnosis is fracture spine D12.
Okay. That was the diagnosis in November.
Lordship,
In November, he was admitted due to fracture of spine.
yes. And his tibia and tibia fibula, I do not have to explain, Lordship. This is related to legs only. It was done in June.
Okay.
That is why there was no accident report, Lordship. And what they did is they file a petition. That petition they have exhibited, Lordship.
Okay. Now, is it your submission that on 24/11 he had a fall and he suffered injuries on his spinal cord? He got admitted in hospital where the history of RTA was mentioned in June.
Even if we take RTA, Lordship, suppose RTA is no.
No, RTA, history of RTA on, you come to next page, next column.
Yes.
Chief complaint.
Yes, alleged
History of RTA on 24. That on that day he met with a road traffic accident.
No, even if what I'm submitting, Lordship, even if we consider that there was an accident in November.
It caused injuries to his spinal cord only.
The deformity is related to his legs.
Okay.
Which was the closed tibia nailing and fibula plating. In this report itself, it is written that it was done in, and that time also he had an RTA. That documents also I had.
Okay, show me that.
Okay, I'll show it.
Okay.
No, they have not exhibited that. They have not exhibited that.
Which you want to exhibit now?
No, that also we have not annexed with our order 41 petition, Lordship. But he had an RTA in June, and where his legs were injured. Here it was only spine, and then the deformity is relating to. So my argument is two-pronged, Lordship. One is that there was no loss of income because he was getting his salary. Secondly, that there was no disability due to the accident in November.
Yes.
He took that treatment and then they found that they can claim compensation, Lordship, if they allege a motor vehicle accident. That's why they filed a petition before the CJM. That is at page 73 to 75, Lordship, of the LCR. And that is the reason, Lordship, in our Order 41 petition, we have annexed the we want to prove the GD entries, which shows two GD entries, which shows that these vehicles were not even involved in any accident. Only a different vehicle was involved.
On 24th, 11.
Yes, that is why we have in our Order 41 petition, Lordship, we have submitted that. In our memo of appeal also, we have given that. These two GD entries, Lordship, translated copies also have given. Some other vehicle was there on that day. Two GD entries are there, but this vehicle or this claimant is not mentioned in those two GD entries. Lordship. That is why the Order 41 petition we want to prove.
Okay. Yes.
So, Lordship, the loss of income of 23 lakhs 10,000 is totally, the claimant is not entitled to this amount because there is no loss, because he has hidden his income certificate, because otherwise it will come out that he is receiving the salary, he is working. Then, Lordship, let me come to the next, though it is 1-1 written, Lordship, medical expenses, Lordship. 3,76,124 the court has given. Before that, Lordship, about the spine, Lordship, I'll also like to show Exhibit 9, 1 and 2, Lordship, page 85 to 86 of LCR, Lordship.
Yes.
These are, because I said that his treatment was regarding spine, Lordship. These are the two documents, their own document, Exhibit 1 and 9, 1 and 2, MRI of lumbar scaling spine, SCR of whole spine. That is dated 27/11/40.
Yes.
Then, Lordship, we will come to medical expenses. Court has given 3,76,124. Lordship, Exhibit 9-4, that is pages, I'll go for pages 87 to 97, 98 to 100, 101 to 100. That means pages 87 to 115, Lordship, photocopies and duplicate.
But he has given a reason that for the purpose of seeking voluntary retirement, he had to deposit the originals and therefore,
Bills and vouchers, Lordship. These are bills and vouchers.
no, he has somewhere stated in his evidence on affidavit that these documents he had to submit for seeking voluntary retirement and therefore he could not deposit the originals.
So he has to then adduce evidence in that manner, Lordship.
Now that is
secondary-
in his evidence part, he has given reason.
That reason, Lordship, that reason.
Under
Then he
60.
should have taken certified copies from his department. He has not given. Some other doctor, Lordship, some Diganta if Fukon has put a seal in all the documents, there is a seal of a doctor. I don't know who that doctor is, that is not proved. In all the documents, Lordship will find, and page 98 to 100 are duplicate. And 87 to 97 and 101 to 115 all photocopy, and the court has given the compensation of 3,76,124 based on these documents, these photocopies.
Okay, why these should not be relied according to you?
Because he has already maybe got his reimbursement from his department. That is why the cross-examination was in that line.
No, but there is no evidence to that effect.
But how photocopy can be accepted by the tribunal? Lordship, tribunal is a inquiring court.
That is why I'm asking. Though he has to submit, their reasoning is when original documents are not available,
Then he has to submit a letter that
then he has to adduce evidence showing reasons as to why he could not adduce or produce original documents.
yes,
He
then
has done so in his.
he has to give a letter that those are received by someone, and that's why he could.
So-
He has not given any.
So your submission is that his oral testimony clarifying the reasons should
It's
not.
double benefit, Lordship. I'm submitting that he is making double benefit here. Once he got it from the.
That is your submission only.
Yes.
No evidence is there that he has got reimbursed.
But is his evidence sufficient, Lordship? His oral testimony that I have submitted it to some authority, there has to be a letter that he has submitted. That letter is to be proved. And all the seals are some doctors. There is some. He has to prove that, Lordship. Burden of proof is on them, not on us, Lordship. It will shift only when they have done their duty.
Okay.
There is no letter showing that he has submitted. Suppose, Lordship, in civil cases, what do? If we have to adduce evidence of certificate? We file a petition that the original is missing, or it is with some authority, we need to file the certified copy or something like that. Lordship, for secondary evidence, we have to. He has not given any petition like that. He has not adduced any evidence
Your
that this.
submission is it falls short of required evidence.
Yes. Maybe the requirement of evidence in MSc cases is less, but that doesn't mean, Lordship, that 3 lakh something will be chiffoned from the insurance company only based on a oral testimony that I have submitted these documents to somebody.
Oral testimony and secondary evidence.
Secondary photocopies, Lordship, secondary.
Photocopies are secondary evidence.
For that, they have to prove according to the Evidence Act, Lordship, secondary evidence, how it's to be proved.
Your submission is that they are unable to prove that. Okay. Okay.
They are unable to do that. Then, Lordship, pain and suffering, transportation, diet, litigation costs. This I'm not challenging, Lordship, because basically maybe he fell or a RTA happened, but this amount, Lordship, the insurance company won't mind. But the other amount, Lordship, by committing fraud, a person is not entitled to a compensation of 27,46,124 in an injury case when that person is getting his salary. There is no loss of income, Lordship.
Now, what are the main documents which you want to bring on record by filing order 41 rule 27 application?
Yes, Lordship. Translated type copy of RTI reply given by the officer in charge. Sorry, first is a copy of hospital report given by the medical superintendent, Pratiksha Hospital. Because, Lordship, this document, Lordship asked about, this is the document which, first document that he had an RTA earlier to November, Lordship. This is the document, Lordship.
Okay.
That is, Lordship, page 8 of my application.
Okay. Then
Because
And what else?
Then Lordship, translated and typed copy of RTI reply given by the officer in charge Jagir Road PS along with GD entry number 687 and 692 dated 24/11/2014. Because on the date of accident, only 2 GD entries are made by
Okay.
these vehicle or the claimant is no way involved. Then copy of letter dated 20.
It is their own case that they never informed police on the date of accident. They filed a complaint case after a month, after about a month.
Because there was no accident, Lordship. That's why I
That
filled
is
that
your
form.
that is your submission.
Yes,
Suppose there is an accident in a place
yes,
and the first priority is to take the injured to the hospital.
correct.
So they took, according to them, they took him to Jagir Road HPC hospital.
Correct.
From there, they took him to
Pratiksha.
Pratiksha.
Correct.
So nobody filed an
But
FIR.
Jagirad hospital document is not there.
No, it is not there, but their oral test.
Their evidence. Okay.
So no FIR could be filed on that day. Therefore, they filed a complaint case later on. How this story is not believable.
Lordship, because of the other things, Lordship. The fraud they are trying to, by fraud, what they are trying to get from the court. If the accident was true, Lordship, there will be I showed that the fall, the Pratiksha hospital, the report is fall. But even if there is a RTA, the amount of compensation given is not correct because there is no loss of income. That is why for the other amount, Lordship, because ultimately insurance company did not deduce evidence, the other amount, Lordship, pain and suffering, transportation, diet and litigation cost, that I have not challenged. And Lordship, my I'll come to Rajkumar Ajay Kumar, Lordship.
किताब खुली मुझसे टैग नहीं टैग लगा दी yes
That I have
yes
to show some.
no the papers are getting loose so,
In the back side.
yes खुली भाल के लगाओ yes what you are submitting
That since he is earning, Lordship, Rajkumar Ajay Kumar is very
which para
para 10 first I'll read, Lordship, and then I'll go to para 12 and 13, Lordship. Ascertainment of the effect of the permanent disability on the actual earning capacity involves 3 steps. The tribunal has to first ascertain what activity the claimant could carry on in spite of permanent disability and what he could not do as a result of the permanent disability. This is also relevant for awarding compensation under the head of loss of amenities of life. The second step is to ascertain his avocation, profession, and nature of work before the accident, as also his age. The third step is to find out whether 1. The claimant is totally disabled from earning any kind of livelihood, or 2. Whether in spite of the permanent disability, the claimant could still effectively carry on the activities and functions which he was earlier carrying on, or 3. Whether he was prevented or restricted from discharging his previous activities and functions but could carry on some other or lesser scale of activity and functions so that he continues to earn or can continue to earn his livelihood. For example, if the left hand of a claimant is amputed, the permanent physical disability or functional disability may be assessed around 60%. If the claimant was a driver or a carpenter, the actual loss of earning capacity may virtually be 100%. If he is neither if he is neither able to drive or do carpentry. On the other hand, if the claimant was a clerk in government office, the loss of his left hand may not result in loss of employment, and he may still be continued as a clerk as he could perform his clerical functions. That's why I'm reading, Lordship. This part is important for our case. And in that event, which is the actual physical and in that event, the loss of earning capacity will not be 100%, as in the case of a driver or carpenter, nor 60%, which is the actual physical disability, but far less. In fact, there may not be any need for to award any compensation under the head of loss of future earning. This is vital, Lordship. If the claimant continues in government service, though he may be awarded compensation under the head of loss of amenities as a consequence of losing his hand, sometimes the injured claimant may not be continued in service, but may not find suitable for discharging the duties attached to the post or job which he was earlier holding on account of his disability, and may therefore be shifted to some other suitable but lesser post with lesser emolument, in which case there should be a limited award under the head of loss of future earning capacity. Taking note of the reduced earning capacity, it may be noted that when compensation is awarded by treating the loss of future earning capacity as 100% or even anything more than 50%, the need to award compensation separately under the head of loss of amenities or loss of expectation or may disappear, and as a result, also a token or nominal amount may be awarded under the head of loss of amenities or loss of expectation of life, or otherwise there may be a duplication in award of compensation, be that as it may be. 12, Lordship. The tribunal should also act with caution if it proposed to accept the expert evidence of doctor who did not treat the injured but who gave ready-to-use disability certificate. Here also, in our case, the doctor who adduced disabilities, proved the disability certificate, had not treated the claimant without proper medical assessment. There are several instances of unscrupulous doctors who, without treating the injured, readily giving liberal disability certificate to help the claimants. But where the disability certificate are given by a duly constituted medical boards, they may be accepted, subject to evidence regarding the genuineness of such certificates. The tribunal may invariably make it a point to require the evidence of the doctor who treated the injured, Lordship, injured or who assessed the permanent disability. Mere production of a disability certificate or discharge certificate will not be proof of extent of disability stated therein, unless the doctor who treated the claimant or who medically examined and assessed the extent of disability of claimant is tendered for cross-examination with reference to the certificate. If the tribunal is not satisfied with the medical evidence produced by the claimant, it can constitute a medical board from a panel maintained by it in consultation with reputed local hospital medical colleges and refer the claimant to such medical board for assessment of them. 13. We now summarize the principle discussed above. All injuries or permanent disabilities arising from injuries do not result in loss of earning capacity. This first one, Lordship, in our case. Because if he is earning, Lordship, there cannot be any. And that's why I read the paragraph 10, Lordship. Someone working in the government office, they do not, because their salary they are getting. Claimant has not proved that his salary is diminished, or that Lordship asked about that he is taking VRS, Lordship. He has not given any proof of those. Those are just said so that he can influence the court, Lordship. Because he cannot produce those documents that he has. So all injuries or permanent disability arising from injuries do not result in loss of earning capacity.
Yes.
So my humble submission, Lordship, the compensation granted at rupees 27 lakhs 46,124 along with 6% interest is to be interfered with, and the claimant is not entitled to any compensation for disability or loss of. And my application, Lordship, because of my arguments which I made in my appeal, Lordship, those documents, their own documents, Lordship will consider those along with my documents, which shows that the injured had taken treatment even before the accident and the disability was resultant of that accident, Lordship. So, Lordship, I for under Order 41 Rules 27 may be allowed so that we can prove these documents. And I'll reply to him.
Yes, Mr. Taluka.
Lordship,
First, do you have any objection
objection.
in the
Lordship.
against the
So far as,
interlocutory application?
allegation of fraud is concerned, my submission is that a genuine case has been projected as a fraud case. Lordship, claimant had examined himself and exhibited FIR, charge sheet, etc. In the charge sheet itself, it appears that there is a prima facie case against the driver of the vehicle concerned. Moreover, one claimant himself was the eyewitness and another independent eyewitness has been examined.
There is a discrepancy.
A charge sheeted witness.
There is a slight discrepancy.
Maybe some, maybe some.
Let me tell you, you answer to that. The claimant who is the injured, he said that accident occurred in front of HPC hospital.
Yes.
And the eyewitness said that it occurred in front of HPC main gate. Now HPC hospital and HPC main gate are.
Lordship, there is little discrepancies for that. The case may not be washed away.
No, my query
Main
is, suppose the distance between HPC hospital and HPC main gate is a small, though there is no cross-examination on this point. But in fact, because we go through those who have crossed Jagi Road, HPC hospital and HPC main gate are far away.
It's inside.
Though there is no evidence.
But that itself creates doubt about the PW2.
No, but there is no cross on that point. That these are.
We will be bringing that in our argument only, Lordship. That
No, that has to
Okay.
come in evidence
I'll
that they are not contact and they are not situated nearby or at the same place. Okay, this just I have pointed out
Little discrepancies, Lordship. Maybe there is mistake.
because she is
Therefore, it
also
is-
alleging that learned counsel for that no accident occurred. It was only there was only a fall. Accident occurred in the month of June, which is reflected from your own exhibit that your tibia and fibula plating and nailing was done in the month of June. And in this accident, which you have reported, only spinal injury took place. And you were operated for spinal injuries only. The discharge certificate is because the disability certificate is for shortening of leg only. That shortening of leg was, the submission is that it was due to the earlier accident. And therefore, to get compensation, you suppress certain facts and committed fraud. That is the allegation.
I have all the answers.
Answer.
Okay. So far as the accident is concerned, the owner and driver filed written statement. They admitted the accident.
Okay.
And lastly, their ground in memo of appeal itself shows that they have admitted the accident, which we have narrated, Lordship. Lordship, kindly see ground number E. For that, the learned member failed to consider that two vehicles were involved in the accident, and by applying the theory of res ipsa loquitur, it becomes clear that vehicle number so and so, motorcycle, was equally responsible for the accident.
Which,
The learned member should have directed the compensation, if at all, the claimant was entitled to be paid by the owner and driver and insurer of both the vehicles. They lordship, they themselves admitted the fact of accident. The claimant side categorically stated in his claim petition as well as in his evidence on affidavit that the accident occurred in front of the main entrance gate of Noga paper mill. And there are several documents in support of that, lordship. Maybe there are some discrepancies in the evidence of eyewitness. Instead of lordship, I'm going through the eyewitness evidence. In his evidence on affidavit, he himself stated that the accident occurred in front of the main entrance gate of the.
yes, that you have stated, that I have gone through. But
Lordship,
in cross-examination, you have stated differently.
moreover, lordship, kindly see the evidence of PW1, the claimant himself, lordship. Along other things, he also stated that I took grievous injury on all parts of my body. I took grievous injury. Lordship, paragraph 2. Ninth line from the top, paragraph 2. I took grievous injuries on all parts of my body. Then, lordship, I am showing that accident information report exhibit 1. Exhibit 1, lordship. Column 3, lordship. 20 date is written as 24/11/2014 at 12 AM on NS highway at Noga paper mill in front of main entrance gate. Exhibit 1, lordship, column 3.
Okay.
Lordship, again, lordship. Lordship, can you see the exhibit 2B? The complaint case was filed before the court, honorable court, lordship. It is specifically stated that since there was some delay in lodging FIR, in fact, for the delay, the police official was not inclined to receive the affair. And that's why a complaint case was filed. And it has been thoroughly narrated here, Lordship. I'm reading out. It is written in Assembly's Lordship. সন্মানপূৰ্বক বিনীত নিবেদন এই যে মই উপৰোক্ত ঠিকনাৰ লোক হওঁ যোৱা 24/11/2014 তাৰিখে দিনৰ 12 মান বজাত মোৰ দেউতা শ্ৰী দীপেন চন্দ্ৰ দাস নাম্বাৰৰ বাইকৰ পিছফালে বহি আহি আছিল মোৰ দেউতাৰ সেই সময়ত so নাম্বাৰ উক্ত বাইকৰ চালক শ্ৰী জুনেৰাম লগত পশ্চিম দিশৰ পৰা নিজৰ ৰাষ্ট্ৰীয় ৰাস্তায় আহি থকা অৱস্থাত ইণ্ডিগো কাৰ এখনে সেই একে দিশৰে প্ৰচণ্ড তীব্ৰ বেগত আহি অসাৱধানতাৰে আহি মোৰ দেউতাক আহি থকা মটৰচাইকেলখনত পিছফালৰ পৰা খুন্দা মাৰে ফলত মোৰ দেউতা গুৰুতৰভাৱে জখম হয় আৰু মই তেওঁক লগে লগে ঘটনাস্থলীত উপস্থিত ৰাইজৰ সহযোগত SPC hospital.
Where is the discharge certificate of HPC hospital?
Discharge certificate.
Though you have annexed that
No, that is there, Lordship.
with the complaint petition.
Lordship, Exhibit 6.
Exhibit 6 is Pratiksha.
Pratiksha, Lordship. SPC hospital, Lordship. Exhibit 5.
Photocopy.
It is specifically mentioned, dated 24/11/2014, Lordship.
Okay. Okay.
Road traffic accident, specifically mentioned.
Now you
Lordship.
come to the point that disability.
Lordship.
That disability was functional disability.
Lordship.
That disability certificate to the extent of 50% was issued
Lordship.
because of shortening of your leg.
Lordship.
But that accident occurred in the month of June 2014.
Same.
How?
24/11/14. Lordship.
No, no. June
June?
2014.
That is another incident. The claimant also.
No, no. You have to show one thing that on the in the accident which occurred on 24th of November, you sustained injuries on your legs. There is no such indication anywhere, apart from the affidavit of the PW1, where he says that I sustained injuries throughout my body. There is nowhere specifically mentioned that there was injuries on leg which resulted in shortening of leg. There is nothing.
Different parts of the body includes leg also.
No. But disability was assessed mainly because of shortening of leg.
So that disability certificate was not challenged. No question was put.
No, challenge is
Regarding
not.
the genuineness of the disability certificate.
Assuming that even it is genuine,
Lordship.
it relates to a different accident.
Lordship, I'm showing it, Lordship. That is Exhibit 5 also. It shows in middle road traffic accident followed by injury and restriction of movement. So and so lower limbs for orthopedic consultations. Reference letter also. Lordship, again, Lordship, kindly see Exhibit 6. column, Lordship. LS history of RTA on 24/11/2014 with LBP, lower back pain, with numbness and tingling sensation with lower extremities. Lower extremities means hip to the toes, from hips to the toes, up to the toes.
Okay.
Then Lordship, then again Lordship kindly see. Exhibit 912, Lordship. Though some of the documents could not be produced, as because some documents have been submitted before the SPC authority, Lordship. That document itself shows, Lordship, Exhibit 912. Pain in area of operation at the left ankle over the lateral malleolus. Operated on 5/4/5/16 for left tibia and fibula fracture. Patient came for follow-up.
No, what you want to show?
Fracture of tibia and fibula.
Yes.
There is a leg injury. Fracture of leg
In the month of June.
in the month of
June.
June. Yes.
Accident occurred.
Treatment is going on continuously. It is not that there's
No, but June accident is not in the question in this MSc case. Here accident occurred in the month of November, 24th of November.
Lordship, it is 4/6/2016. He was under treatment continuously for 2 years. Bedridden, Lordship.
Yes, what else is your submission?
My submission is that
And there is no loss of earning capacity.
loss of software, I'm fairly submitting less, Lordship. Though he submitted application for voluntary retirement, but that is not accepted, Lordship.
When
So
he's still in service or when?
he's not now retired.
When he retired?
I actually cannot say, but at the time of accident of 2014, he was 55.
So his prayer for voluntary retirement was not allowed.
I think or not allowed. So
Then-
some
then
loss,
where is-
some number of days he was absent from his duty. Their document itself shows that in the month of December 2014, his attendance was less than 10 days. Lordship, can we see?
That is our idea.
Okay. Anything else?
So far as fraud is concerned, Lordship, kindly see there, though whether it will be accepted by Lordship or not, that order application under Order 41, Rule 27, but their document, I'm showing it, Lordship, kindly see, 2 incidents occurred under the jurisdiction of Jagirit Police Station. One in front of the main entrance gate of Noga paper mill, and another is Tarangapar, the place in between Jagirod and Morigaon. The Lanet Tribunal, the insurance company showing the GD entry of another incident, want to project it as a false or fraud case. Lordship, can you see Exhibit 12? Lordship, in their application, Order 41, Rule 27. At page 12, Lordship. In the entry number has been mentioned, type copy, translated copy.
Yes.
In first paragraph, now from Tarangapar via telephone inform 1 I-20 vehicle hit a cyclist, caused grievous injury in moving towards
Okay,
Jagirod.
this is not that incident.
Not that incident, but showing that incident, the insurance company want to project it. The present case is a fraud case.
No, no,
No,
no, what we
no,
want.
their submission is that on that day, only 2 GD entries were registered.
Lordship,
And none of the GD entry relates to your accident.
Lordship,
Therefore, no accident occurred on that day. That is their submission. Their submission is that had there been any accident,
Lordship.
a third GD entry would have been there, which is not there.
In respect of that accident, that incident, another incident,
No.
not present relation.
No, her submission is that on that day, only 2 GD entry were registered in
Lordship.
Jagirod police station. And none relates to your case.
Yes.
Had there been an accident on that day,
Lordship.
had you suffered with an accident, there would have been a GD entry in your case too. That is her submission.
Lordship, where charge sheet is there, eyewitness evidence is there, independent eyewitness, and the owner and driver of the vehicle in question admitted the fact of accident. What remains, Lordship? And so far as disability is concerned, they have not challenged the disability certificate. The genuineness of the certificate has not been questioned. So it should be accepted. Lordship, so far as my submission is that for loss of income, some lump sum amount may be awarded. Because it shows from the document that they were absent, he was absent on different occasions, could not do his duty. And salary was not given. My Lordship, so far as the incident 26/2014, that incident, that is another incident. Earlier also he sustained injury due to the accident, and he was admitted in the same hospital. But here in this case, the document shows sufficient document is there, Lordship. Exhibit 6 is there. Exhibit, he was admitted on 24/11. And again, Exhibit 7. And one operation was done. Moreover, Lordship, for the purpose of a voluntary retirement, They applied and the SPC authority wrote to the superintendent of Moriga Civil Hospital. Accordingly, board, medical board was constituted and they given their opinion, Lordship. Exhibit 8, Lordship. Impression, that is the below, Lordship, impression. From physical examination and examination of all records, it is found that the person concerned cannot walk properly, cannot step forward, and cannot be in one position for a long time. So it is not possible for him to do regular duties effectively. So far as examination of doctor is concerned, Lordship, I'm showing it. The doctor himself examined, stated in his cross-examination, I clinically, Lordship, can you see cross-examination of Dr. Lordship? The injured person was examined in medical board where I was also a member. He was also a member of the medical board. In the disability certificate, I only put my signature. I found 50% disability due to the shortening and deformation of both legs with multiple fracture due to the road traffic accident. Before issuing the disability certificate, I clinically examined the injured, and there is hardly any chance of his recovery from his disability. There is no, it is not disputed. And moreover, in his examination chief stated at page 2, paragraph 4 and 5. 4, in my opinion, the injured never do any physical hard work as cycling, driving, weightlifting, racing due to said injury, unable to conduct his necessary day-to-day work due to aforesaid injuries. Again, 5, that injured has to require one attendant for solving his day-to-day activities for entire life.
I'll give a short reply.
No, I
How much
have to
time?
lost,
How much time?
15 to 20 minutes.
Okay, we'll continue at 2.
Lordship.
Item number 31. You have informed the. We'll adjourn it. We'll adjourn it. Item number 31, Manutrakhi. We'll fix a date in the month of November.
So far as medical reimbursement is concerned, they could not produce any document in this regard. Moreover, in suggestion, question was put, but the claimant denied it. And so far as Lordship, documents exhibited, Lordship, the claimant has stated that all the original documents have been submitted before the authority concerned. And that document, while exhibiting that document, it was not objected by the other side.
Okay.
So far as loss of income is concerned, Lordship, considering his age, 55 years, and his occupation is not disputed, Lordship. So only for at least 1 year, loss of income may be considered.
On what basis? On what basis?
He could not attend his duties.
For 1 year.
This 6 6 months.
No, for those 6 months also you got salary.
See.
You have not shown that
Less, lordship, in their.
you exhibited.
documentation, he could attend his duty in the month of December, less than 10 days.
No, but you have not shown anything to indicate that for these months you get lesser salary and therefore that should be compensated. There is no evidence on that.
I am leaving it to the lordship. Lump sum amount may be granted, lordship. As so far as other heads are concerned, lordship, amount awarded on pain and suffering, much on the lower side, lordship. Only 25% to 1,000 has been granted. So considering the gravity of injury and disability and long treatment, at least 1,50,000 should have been granted.
Yes.
There
And
is,
lordship,
there
other
is no
aspect of
appeal
the-
filed by them
For,
that to
for future
enhance.
treatment. So, at least 1,50,000 may be granted. And
Lordship,
other aspect
where
of
is
model,
this coming from?
loss of
I don't understand.
amenities and loss of expectation of life. 1 lakh each may be granted, and for attendance charges.
So the gist is that insurance company has to oppose everything and the claimant has to claim as much possible as.
Yes, and out of nowhere, like asman se gira.
Normally, on that heads, the amount
Okay.
is awarded. Lordship, in that
Normally.
respect,
That is normally.
even if in case of the teacher.
Kuntu case. Kuntu case kua.
What is
Even if in case of without cross objection or cross appeal, the amount may be increased.
no, that power is there. Power is there,
Last
but is it a case where that power should be exercised?
No,
What prevented you?
Ranjana Prakash Supreme Court judgment is there that if in the insurance
No, there is a constitution bench judgment which I have mentioned in yesterday's judgment, in which you are one of the counsel.
Ranjana Prakash, I had submitted.
Ranjana Prakash is division bench judgment.
Acha.
A constitution bench judgment is there that under Order 41 Rule 33, court has power to grant reliefs even in absence of cross objection.
But in this case, where is it coming from?
But that does not mean that in every case when
Lordship, that is there. Lordship,
you have to make out a case.
Lordship, here in this case, Lordship, considering the gravity of injuries, disability, and long treatment,
Disability is question.
Lordship.
Okay.
And
Now he's conceding on the loss of earning. It is 23 lakhs something.
Goes.
That goes. That he's saying that instead of that, give me 1 lakh for 1 year.
Where is that?
That is his submission.
That-
Now are you pressing the Order 41 Rule 27 application?
I told Lordship that even without that, my case is strong with their own document because I showed their exhibits, Lordship, 81 and at page exhibit 6. Both are exhibit 6, page 81 and 82, Lordship. The alleged.
Any reply, brief reply,
Yes.
if you want.
No, Lordship, the fact that he submitted that we have given a fraud case, we have mentioned it. Now, because of his submission itself, Lordship, it comes out that when he has not taken VRS, when his evidence and claim petition, he is saying something about VRS when it has not been done, Lordship. The fact that he submitted the medical documents, that itself goes also, Lordship. Because photocopies are given, that proves that he had submitted, no doubt he had submitted them to his office, but to get reimbursement, Lordship, not for VRS. Now their submission itself proves that part, Lordship.
That is also submission.
Yes. because he is submitting now that no VRS is taken. If no VRS taken, his submission in his evidence, he had said that those documents are given because of VRS. It is not.
He's submitting that VRS was not allowed.
No, there is nothing, Lordship. It was that it was applied also, that is not there. My
No,
submission
that you have already submitted.
yes, already submitted. So the question that it was not given is not here, and the documents, medical expenditure, Lordship, it is not to be considered because those are all photocopies. It's not a question of tribunal is an inquiring court, Lordship. It has to look at the, and I already said that secondary evidence, if they have to give, they have to submit.
Ms. Adi Majumdar, the learned counsel for the appellant, also Mr. M. Talukdar, the learned counsel for the respondent slash claimant. This appeal under section 173 of Motor Vehicles Act 1988 has been preferred by the appellant Messrs. Oriental Insurance Company Limited, impugning the judgment and award dated 21/3/2018 passed by the Motor Accident Claims Tribunal Morrigaon in MEC case number 23/2015, whereby the present appellant has been directed to pay a compensation amount of rupees 27,46,124 to the claimant slash respondent along with an interest at the rate of 6% per annum. The facts relevant for consideration of this appeal, in brief, are that the present respondent number 1 slash claimant had approached the Motor Accident Claims Tribunal Morrigaon by filing an application under section 166 of the Motor Vehicles Act seeking compensation on account of injuries sustained by him in the road traffic accident which occurred on 24/11/2014 at about 12 noon on National Highway in front of the main entrance gate of Nagaon Paper Mill, Jagi Road. Stop. It is alleged by the, it has been stated by the present respondent number 1 slash claimant in his application under section 166 MVA Motor Vehicles Act before the tribunal that on the fateful day, that is on 24/11/2014, he was going from Jagi Road towards his house on a motorcycle as a pillion rider. Stop. The motorcycle was registered. Motorcycle was having registration number AS01 V3346. Stop. When they said they reached in front of the main entrance gate of Nagaon Paper Mill, Jagi Road, one Indigo car bearing registration number AS12L6713 coming from the same direction in a very at a very high speed hit the said motorcycle from backside, as a result of which both the driver as well as pillion rider of the motorcycle fell down and they sustained injuries on different parts of their body. Immediately both of them were taken to Nagaon Paper Mill Hospital, and from there they were referred to Pratiksha Hospital, Gauhati, considering the seriousness of the injury sustained by them. The claim case filed by the respondent number 1/claimant was registered as MAC within bracket injury case number 23/2015. The present appellant as well as the owner and driver of the offending vehicle contested the case by filing written statements wherein they denied their liability to compensate the present appellant on account of the aforementioned accident. The Motor Accident Claims Tribunal, Morigaon, after going through the pleadings of both the parties, framed following issues. Quote A from page 9 and 10. In support of his case, the claimant examined 3 witnesses, that is, he himself adduced evidence as PW1 and 1 eyewitness as PW2 and 1 doctor as PW3. The insurance company did not adduce any evidence against the claim of any evidence in the said inquiry before the Motor Accident Claims Tribunal. Ultimately, by the judgment and award which has been impugned in this appeal, the claim petition was allowed. Claim petition filed by the respondent number 1 claimant was allowed, and he was awarded compensation in the manner as already been described in the foregoing paragraph of this case, of this foregoing paragraphs of the judgment. Next paragraph. It is pertinent to mention herein that during the pendency of this appeal, the insurance company / appellant had also filed an application under Order 41, Rule 27 of the Code of Civil Procedure 1908 for allowing the appellant to produce additional evidence at the appellate stage. It prayed for allowing the appellant to bring on record certain documents like RTI reply given by officer in charge of Jagir Road Police Station, along with GD entry number 687 and 692, payslip of the respondent number 1, Anything else?
And hospital report, Lordship. The first one is hospital report. His admission in
And hospital reports. Hospital report given by
Pratiksha Hospital.
Medical Superintendent Pratiksha Hospital. Stop. Miss R.D. Majumdar, the learned counsel for the appellant, has submitted that the appellant has also alleged fraud on the part of the claimant in suppressing some vital documents from the Motor Accident Claims Tribunal during the inquiry. As such, she submits that to prove the allegation of fraud, some allegation of frauds, the documents which are intended to brought on record by way of additional evidence are required to be placed before the court. As such, she submits that the application under Order 41, Rule 27 of the Code of Civil Procedure submitted by the appellant may be allowed. She also submits that the appellant could not have produced these documents before the tribunal in spite of due diligence on their part. Stop. She further submits that even from the documents on record, it is apparent documents, even from documents which are exhibited by the respondent number 1, the fraud played upon the tribunal is apparent. She submits that the Motor Accident Claims Tribunal, Morrigaon, has erred in awarding the compensation to the claimant on account of loss of earning capacity without there being any material on record to suggest that the respondent number 1 claimant has suffered from loss of earning capacity. She submits that no income certificate or salary slip has been exhibited by the claimant / respondent number 1 before the tribunal to establish that his income is at the time of accident was rupees 35,000 per month. She submits that apart from oral testimony nothing has been brought on record regarding the income of the respondent number one claimant. Stop. She further submits that though the claimant slash respondent number one, while deposing as PW1, has deposed that he has applied for voluntary retirement. However, no documents to that effect could be produced before the tribunal, and there is no material on record which indicates that the respondent number one had been allowed to take voluntary retirement, and on that account he had suffered any pecuniary loss. She submits that the tribunal erred in assessing the loss of earning capacity to the tune of rupees 23 lakhs 10,000 without there being any material to substantiate this same on record. She further submits that during his cross-examination, PW1 has admitted that after the accident he joined his services, which itself indicates that he was not allowed to, his prayer for no, he was not released on voluntary retirement, and there was no loss of any earning capacity.
He also says after taking rest for 3 months. So what, if at all 3 months, there is no loss.
Then counsel for the appellant further submits that the only evidence on record is that only evidence on record regarding loss of income is regarding his absence from service for a period of 3 months, during which he was not paid any salary.
No, that is not there, Lordship. Only evidence is that he was in hospital for 7 days, Lordship, because Pratiksha Hospital evidence, the report is there. He was hospitalized from 24/11/2014 to 30/11/2014. Only 7 days.
Somewhere in his oral evidence.
That is document 81 and 82, exhibit 6. Discharge certificate is at 82, page 82 of LCR. Exhibit 6.
Stop. In a period of 5 months, during which he was not paid any salary. However, he has not produced any documentary evidence to that effect. She further submits that the discharge certificate, which was exhibited as exhibit 6, indicates that the claimant slash respondent was admitted as
Seven also there.
6 and 7, which indicates that the claimant slash respondent number 1 was admitted in the hospital on the date of accident, that is 24/11/2014, and he was released therefrom on 30/11/2014. As such, as such, she submits that
Exhibit 7 may also be mentioned.
there may be loss of income for only these 6 days, 7 days,
6 days.
6 days. She further submits that the claimant, next para, she further, next para, the learned counsel for the appellant further submits that the claimant slash respondent has committed fraud upon the tribunal by suppressing the fact that the injury sustained by him on his legs was due to an earlier accident which occurred in the month of June 2014.
26, 2000.
She further submits that even on perusal of the discharge and disability certificate, which is exhibited as exhibit
Disability is exhibit 41,
exhibit 41.
page 116.
It appears that the said certificate was issued as the claimant respondent number 1 suffered from locomotive disability on account of shortening and deformation of both legs following fracture of lower limbs due to RTA. However, she submits that on perusal of the discharge certificate, which is exhibited as exhibit 6, as well as exhibit 7, exhibit 6, discharge certificate, which is exhibited exhibit 6,
Page 82,
it appears that
diagnosis.
he was diagnosed
Fracture spine D12.
that on 24/11/2014, he was diagnosed with a fracture spine, with a fracture spine D12. She also submits that even the MRI reports, which are exhibited as exhibit 9.1 and 9.2, it suggests that the claimant sustained burst fracture of D12. As such, she submits that the injuries sustained by the claimant on 24/11/2014 was only in respect of spine, that is, he sustained only spinal injuries. She further submits that the discharge certificate exhibited by the claimant, respondent number 1, as Exhibit 6, also indicate that on 24/11/2014, the doctors while recording the past history of the ailments of the claimant/respondent number 1, indicated that one closed tibia nailing and fibula plating was done on the claimant in the month of June 2014. She therefore submits that the injury sustained by the claimant in his legs was prior to the accident which occurred on 24/11/2014. She further submits that Exhibit 6 also indicates that there might not be any injuries due to road traffic accident, as the said exhibit, while recording history of the patient, indicates that there is a alleged history of fall on that day at about 12 p.m. at Jagi Road, without specifically indicating that the patient suffered injury in a road traffic accident. She submits that had the claimant/respondent number 1 met with an accident on that day, it would have been clearly recorded in the discharge certificate, in the medical document, which is exhibited as Exhibit 6. She therefore submits that the disability certificate exhibited as Exhibit 41 and the evidence of doctor to that effect pertains to injury suffered by the claimant/respondent number 1 prior to 24/11/2014, and as such he is not entitled to any compensation on that account. She further submits that next para. The learned counsel for the appellant further submits that the tribunal has also erred in awarding a compensation amount of rupees 3,76,124 to the claimant against medical expenses. She submits that the medical expense, the bills/prescriptions/vouchers exhibited as Exhibit 87 to Exhibit 115 by the claimant before the tribunal are all photostat copies.
one more thing, Lordship, and moreover, they are related to this spinal treatment as well as fibula and removal of fixation. Because in December he was admitted, that was for removal of his implant in left tibia and fibula fracture. So the documents are related to.
All photostat copies of doc and the claimant has not been able to satisfy the prerequisite conditions as mentioned in Section 65 of the Indian Evidence Act before adducing secondary evidence. She submits that though the claimant has stated that the said documents were submitted before the Jagiroad paper mill authorities for praying for allowing the claimant to go on voluntary retirement. However, as no documents regarding voluntary retirement could be produced by the claimant responding number 1, there is every probability that he might have reimbursed the said medical bills from his employer, and as such, no compensation should be awarded against medical expenditures, medical expenses also.
And also because the medical expenses include his treatment for tibia and fibula.
She further submits that the medical vouchers and documents exhibited as Exhibit 87 to 115 includes expenses incurred by the claimant not only for the spinal injuries which he sustained on 24/11/2014, but also for the injuries sustained by him in his earlier accident, and as such, he is not entitled to get reimbursement regarding all the medical expense and expenditure indicated by the documents exhibited by him before the tribunal. In support of her submission, the learned counsel for the appellant has cited following rulings. Rajkumar versus Ajay Kumar and another, reported in 2011 1 SCC. Hmm. 2011 1 SCC 343. Number 2, United Insurance Company Limited versus Rajendra Singh and others, reported in AR 2000 SC 1165. In the Oriental Insurance Company Limited versus Srimati Lakhi Das, order dated 17/7/2018 in MSC case number 84/2017. On the other hand, Mr. M. Talukdar, the learned counsel for the appellant, learned counsel for the complainant, this respondent number 1 has submitted that the motor accident claims tribunal has fairly submitted that the claimant / respondent number 1 was not allowed to go on voluntary retirement, and as such, apart from the dates on which he could not attend his duties, for which he was not paid any salary, he did not suffer any loss of earnings. However, he submits that considering the seriousness of injuries sustained by him and period for which he had to abstain from his duties, as a result of which he did not get salary for the said period. His loss of income may be assessed on a lump sum basis, taking his absence from service for a period of 1 year. He further submits that the tribunal has assessed and allowed the compensation to the claimant on other conventional heads on a much lower side, and same is required to be enhanced, though there is no cross objection from the side of the claimant. He submits that in a fit case, even in absence of a cross objection, if the court deems it proper to enhance the compensation against a particular head, it can do so. In support of his submission, he has cited ruling of a coordinate bench of this court in the case of Oriental Insurance Company Limited versus P. Khan Bala Das and others, reported in 2014 to GLT. $855.
Another document is there.
855. As well as another ruling of the apex court in the case of Jitendra Kim Shankar Trivedi and others versus Kasam Daud Kumbhar and others, reported in 2015 1 TAC 673 SC. He further submits that no fraud has been played upon the court as alleged by the learned counsel for the appellant. He submits that in the instant case, due to reasons stated in the complaint filed by the son of the claimant, the FIR could not be filed on the date when the accident occurred, that is on 24/11/2020. 2014. However, belatedly, the son of the claimant filed a complaint before the Court of Chief Judicial Magistrate Morrigaon, which was directed to be registered as an FIR. He submits that on the basis of the said FIR, an investigation was initiated and ultimately charge sheet was laid against the driver of the offending vehicle, which indicates to the truthfulness of the contentions raised by the claimant in his claim petition. He further submits that even the owner and driver of the offending vehicle who were impleaded as respondent number, opposite party number 2 and 3 before the 2 and 3 in the MSC case number it is the
23 of 2015.
23 of 2015 before the Motor Accident Claims Tribunal, Morrigaon, had in their written statement admitted the fact of accident. He further submits that even the present appellant in ground number E.
One eyewitness was examined.
Huh?
Eyewitness.
Oh, yes. Even in Calica. Ground number E of the memo of appeal had indicated the fact that the appellant also admits that the accident occurred on 24/11/2014. Stop. He submits that apart from the above, one independent eyewitness was also examined as a PW2 before the tribunal, who had deposed regarding the fact of the accident. He further submits that as regards the fact that the claimant could not produce original documents before the tribunal, reason for the same has been stated by the claimant while deposing as PW1 in his oral testimony, to the effect that the said documents originals of the said documents had to be deposited with his application for voluntary retirement. As such, he could not submit original documents before the tribunal. Stop. Learned counsel for the respondent further submits that at the time of exhibiting photocopies of the documents exhibited as Exhibit 87 to 115. 87 to 115. No objection was raised by the insurance company before the motor accident. No objection was raised by the counsel of the insurance company before the motor accident claims tribunal. Neither any query was, during cross-examination whether this point was raised.
Pause or নিমিষে only?
Neither any. Neither any point was there. Neither the PW1 was confronted on this point by the learned counsel for the insurance company. As such, he submits that at this stage, the insurance company cannot take that plea.
Lordship, just sorry, that 87 to 115 is page number, Lordship, but exhibit is 9 in bracket 4 series and 10 series. Exhibits are that 87 to something like that.
Exhibit 9 series and exhibit 10
10
series.
yes.
Okay. Learned counsel for the appellant. Learned counsel for the respondent number 1 / claimant further submits that the compensation awarded to the claimant on account of pain and suffering is only a paltry sum of rupees 25,000, which is required to be enhanced to minimum 1,50,000 on account of the seriousness of the injury sustained by the claimant respondent. He further submits that the compensation awarded against other conventional heads like transportation, diet, and litigation cost is also required to be enhanced. He therefore submits that the appeal filed by the insurance company lacks merit and deserve to be dismissed. Stop. I have considered the submissions.
Further Lordship, Exhibit 5, I've mentioned. Exhibit 5,
Yes.
road traffic accident, which is mentioned, road traffic accident followed by injury and restriction of movement, lower limbs for orthopedic conservation, it is mentioned. So due to the accident, he suffered.
He also, ये
And also-
paragraph ऊपर जाएगा. He also submits that though the claimant had met with this you are admitting that earlier also there was an accident.
But this is not there, it is not mentioned that earlier. This,
No, your submission, are you,
earlier also.
you are admitting, though the claimant met with an accident on earlier occasion also, however, he sustained injuries on his limbs, both limbs, due to the accident which occurred on 24/11/2014, which is apparent from Exhibit 5, which is the referral form issued by the Nagaon Paper Mill Hospital, which indicate that the claimant suffered from road traffic accident followed by injury and restriction of movement of what?
Lower limbs.
Of lower limbs,
Further Lordship,
and was advised for orthopedic consultation.
again, Lordship, Exhibit 912, Lordship. Is mentioned pain in the area of operation at the left ankle over the lateral malleolus, operated on 4/5/16 for left tibia and fibula. fracture.
Yes, that, in fact, Lordship, if Lordship will examine exhibit 7, he mentioned about it at 83, Lordship. Those 1,93,634 was for that tibia and fibula.
Learned
not
counsel for the claimant slash respondent number 1 submitted that the injuries sustained by the claimant on 24/11/2014 had to be treated for long period thereafter, and in that regard he was also operated upon on
4/5/2016.
4/6/2016
4/5/2016.
on 4/5/2016,
Exhibit 9/12.
which is indicated by exhibit 9 within bracket 12. Stop. ये सब ऊपर जाएगा. Last paragraph की ऐसे ने. I have heard learned counsel for both sides and have gone through I have considered the submissions made by learned counsel for both sides. I have also gone through the materials available on record, including the case record of MEC case number 23/2015. I have also gone through the rulings cited by learned counsel for both sides in support of their respective submission. Judgment reserved.
Highly obliged. Lordship.
And production is item 1.
To detail. Open detail. Lordship, written argument. I have already supplied a copy to him.
What is production list?
Production list is the order 41 rule 27 application which I had filed, Your Lordship. And they have filed their objection.
You want to make any submission?
My lord, already I have brought my submissions in my affidavit in opposition filed against this application.
They have
And my
a,
lord, in support of my objection, my lord, I am relying upon three judgments of the application, my lord. Because my lord,
No, what you want to,
well, this is inadmissible now.
No, let him submit
Oh.
first.
my contention, Your Lordship, is because, as Your Lordship, I had pointed out, there was one finding arrived at by the learned trial court with regard to the fact that the executive engineer did not have the authority to terminate.
Yes.
Now, this, because the contract was entered into by the chief engineer and this. Now, my contention before Your Lordship was through this, while arguing also, I had urged that this point was not even in the pleading while assailing the termination letter. Now, this, and as this was not one of the points, there was no occasion on the part of the defendants, the appellant here, to place on record any such documents to establish the power of the executive engineer to terminate the contract, because the termination per se was challenged. The power of the executive engineer as on the ground that the contract was entered into by the chief engineer and the termination was done by the,
Where is that power?
and because of which these two documents we have placed on record.
Which document number?
Uh,
Lecture X.
X and Y, Your Lordship. Because in page 14 of my application, I have brought on record a letter addressed by the executive engineer seeking his to inform you that the contractor has miserably failed to complete the work such and such. Thereby, you are requested to give necessary direction to take any further action from this end. And thereafter, annexure Y, your lordship will find, is that upon receipt of the aforesaid letter, the chief engineer had stated that with reference to above letter, you are directed to terminate the contract from your end as authorized.
No, but it does not empower him to terminate. Annexure X only.
No, it was his request to give appropriate direction, annexure A.
So this appropriate direction includes power to terminate.
That comes under, because under, with reference to my annexure X, which is letter dated 21/4/2010. This is referred to in annexure Y in the reference that 24/4/2010. In the reference column where it is stated that in reference to the letter above, you are authorized to terminate from your end.
No, is it your submission that in annexure A, the words to give necessary direction?
This was a direction to
So
terminate.
to give necessary direction includes power to terminate also.
That is what has come.
That is your
chief engineer had sought for that. He has miserably failed. So he had sought for, you are requested to give necessary direction to take any further action from this end. Now, upon receipt of this, the chief engineer has directed the executive engineer to terminate the contract. That is annexure Y.
Oh, okay. You're directed. Okay.
Because of this follow-up, your lord.
Okay. So chief engineer directed him to terminate.
That is what, because as this was not a contention before during the trial court, these two documents, though was there, was not filed, your lordship. So under this, because this has come up after the judgment was passed, this application has been filed, your lordship. My learned colleague has taken the plea that this is to fill up the lacuna which is there, and it is a manufactured document. That is his stand also.
Yes, Mr. Alam.
See, for this purpose, for the purpose of consideration of these two documents, you also cannot see annexure 8 of the plaintiff pilot. Annexure 8.
Annexure 8 of
Plaintiff pilot during the trial. Annexure is the termination order dated.
where is annexure 8?
Annexure 8 is TCR, my lord. TCR.
Trial court record, your lord.
Oh, okay. You read it. What is
Yes, my lord. This was issued, my lord, on 26/5/2010. Now, your lordship may take a judicial note of this day. 26/5/2010.
Yes.
My lord, now we are in the year 2026. After almost 26 years of this termination, my lord. As such, invoking, my lordship, I cannot see, this termination letter was issued by invoking clause number 52.2 of GCC, which does not empower him.
To delegate.
My lord.
Does not empower him to
Empower
work.
him to terminate the contract because he was not the employer. As per clause 52, chief engineer is the employer. My lord.
But,
He has not stated in this termination as authorized by employer, I am terminating your contract. This is not the context of the termination letter. So, my lord, this can very well be presumed that this is an afterthought story of the appellant's exhibit. Furthermore, my lord, regarding these two documents, my lord, there is nothing on, no pleadings is there. Either before the trial court or even before this Honorable Court also. Because, my lord, in this, before this Honorable Court, they are challenging the findings recorded by the London Trial Court while deciding issue number 3. Lordship, I cannot see page number 25 of memo of appeal. They are challenging this order, wherein the London Trial Court has held that this was illegally and unauthorizedly terminated. Thereafter, they have approved this Honorable Court. Why they have not pleaded this? That this termination was not unauthorized, rather as approved by the chief engineer. There is nothing on in the memo of appeal. My lord, this matter went up to the appeals court. This matter is now before your lordship on being remanded by the apex court. Nowhere in the entire proceedings these documents have found place.
It was with regard to
Please, sir.
limitation that was
Please, sir.
there.
Please, sir.
Yes.
So, my lord, while deciding the issue number 3, this is the finding of the learned trial court that this was illegally and unauthorizedly terminated. Thereafter, they approached this honorable court by filing this appeal. What had prevented them to bring these 2 documents on record? Even plead that also. No, this was not illegally terminated. This was illegally terminated as per approval of the chief minister. Is there anything on record to show before this honorable court?
So due diligence is not there.
No, dear, nothing, my lord. This is just a attempt, my lord, to fill up the lacuna, which is not permissible. This objection, my lord, I have raised these issues. I have raised my objection, my lord.
Okay. Objection is there on record.
On record, my lord. They filed it day before yesterday. And
Their
yesterday,
objection is there.
yesterday itself, I filed my objection.
Okay.
And my lord, in support of, sir, please, in support of my objection, my lord, I am relying upon 3 judgments. 2007 4 ECC 780. Satish Kumar.
2000.
2017 4 ECC 760.
What it says, paragraph number.
Paragraph
You-
19
you
and 20, my lord.
Mention the paragraph on.
Yes,
the-
yes, my lord. I have highlighted.
Okay.
I have highlighted too. May I read, my lord? Paragraph 19, that is serial page number 12, my lord.
Yes.
The other part of the appeal order permitting additional evidence and demanding the case for face decision is uncalled for. No case was made out for permitting additional evidence on settled principle under Order 41 Rule 27 CPC. Provisions have been quoted, my lord. Now, the appellate court may allow such evidence or document to be produced or witness to be examined. Or evidence. It is clear that the other trial court has refused to receive the evidences. Neither the trial court has refused to receive the evidences, nor it could be said that the evidences sought to be adduced was not available despite exercise of due diligence, nor it could be held to be necessary for pronouncement of judgment. Additional evidence cannot be permitted to fill in the lacuna or patch up the weak points in the case, which is the attempt of the appellant before this on the court now. Because, my lord, in this case, your lordship cannot consider. Arguments have been concluded. It is pending only for submission of written for submitting the written submission of both the parties. I've already filed. On the day of my filing written submission, my lord, this application was brought on record. My next submission, my lord. 2003 4 ECC page 161 paragraph 17. Your lordship may can see serial page number 2003 4 ECC 161 para 7. Internal page number 21, my lord, of my compilation.
Yes. Page number?
21, my lord.
This compilation which you
My
have.
lord, now my lord, I have supplied 2 days. I have my lord submitted 3 judgments. This was taken, my lord.
Yes.
Page 21.
Yes.
Paragraph 7, my lord. I'm reading, my lord. As regards the plea of certainty me argued on behalf of the defendants by the learned counsel. First, we may note that this plea was never taken in the written statement the way it has been put now. The written statement is totally vague and lacking in material particulars on this aspect. There is nothing to support this plea except some alleged revenue entries. It is settled law that in absence of plea, no amount of evidence laid in relation thereto can be looked into. Therefore, in the absence of clear plea regarding subtenancy, the defendants cannot be allowed to build up in the case of subtenancy. Had the defendants taken such plea, it would have found place as an issue in the suit. We have perused the issue, then in the suit, there is no such issue on the point of law, on this point. Last, my lord, this is unreported judgment dated, my lord. August 22 August of 25. This is not reported. Civil I'll provide you.
INC number.
INSC number 1027. 25 INSC 1027. My lord, in this judgment, paragraph 7 and 8 are relevant. Internal page 34, my lord.
Yes.
Paragraph 7, my lord. In the application prepared under Order 41 Rule 27 of the Code, the defendant stated that he got the information that there was no such sale by the plaintiff in the last week of June 2000. After making inquiries in the office of the service star, he got such information and obtained certified copies of the extract of the document. It can be seen that High Court has proceeded to consider the application under provisions of Order 41 Rule 27 of CPC without examining as to whether the additional evidence sought to be laid was supported by pleadings of the defendants in the WS, which is lacking in this case, my lord. Right, my lord. In our opinion, before undertaking the exercise of considering whether a party is entitled to lay additional evidence under Order 41 Rule 27 of Code, it will be first necessary to examine the pleadings of such party to whether if the case sought to be set up is pleaded so as to support the additional evidence that is proposed to be brought on record. In absence of necessary pleadings in that regard, permitting a party to lay additional evidence would result to an unnecessary exercise, and such evidence, if laid, would be of no consequences, as it may not be permissible to take such evidence on record into consideration. Now, my lord, these are the two judgments relied upon. And finding, my lord, appellate court to consider the pleadings of the parties seeking to lay such additional evidence. It is only thereafter, on being satisfied that the case was contemplated by the provisions of Order 41 Rule 27 of Code has been made out, that such permission can be granted. In absence of such exercise being undertaken by the High Court, in the present case, we are of the view that it committed an error in allowing application moved by the defendants for leading additional evidence. These are my submissions, my lord, against this application, my lord, now, which has been filed after 26 years of termination.
In RFL, in main appeal heard Mr. A. Bishwas, learned counsel for the appellant. Also heard Mr. A. N. Alam, learned counsel for the respondent. Learned counsel for both the parties have submitted written gist of their argument as was directed by this court. Stop. It also is pertinent to me. It is also pertinent to mention within that today the appellant has also filed an interlocutory application under Order 41 Rule 27 read with Section 151 of the Code of Civil Procedure 1908 to bring on record two documents by way of additional evidence at appellate stage.
Lordship, one more serious my lord, I wanted to submit before your lordship. The lordship I cannot see in actual Y. In actual Y, my lord, they now say that this is the authorization given by the employer, that is chief engineer. My lord, lordship I cannot see. This letter was having a reference of letter dated 25/2/2010. Letter is not on record.
No, that is a different order. In reference.
Which letter?
25/2/2010 in annexure Y, my lord, page 15 of IA. Page 15 of IA, my lord.
Yes, page 15 of what you want to say.
My lord, with reference to the above letter, you were directed to terminate the contract from your end as authorized by this office or letter dated 25/2/2010. Where is that letter? What was that authority? Whether this was in conformity of GCC or beyond GCC? Why they have not produced this letter?
Okay. Yeah.
Yeah.
Appellate stage to show that the executive engineer Dibrugarh Rural Road Division was authorized by the chief engineer PWD Roads on Assam to terminate the contract, which is the subject matter of dispute in this field. The respondent side has filed a written affidavit in opposition, opposing the application filed by the appellant under Order 41 Rule 27. I have heard learned counsel for both sides on the said interlocutory application. The order as regards the said interlocutory application shall be known. Continue. The order for continue. This interlocutory application shall be considered while considering the submissions made by learned counsel for both sides in the connected FAO, in the instant RFA, and necessary orders to that effect shall be passed. The judgment in
Yes,
RFA is reserved. Yes.
Sorry to interrupt, Your Lordship. In my written argument with regard to Order 41 Rule 27, two judgments have already been filed.
You mentioned here.
It is mentioned. It is serial number 6 and 7 of my compilation at page 10. I have given the list, Your Lordship. The serial number is State of Rajasthan versus this two judgments on the basis on the.
Okay, I'll go through it. I'll consider I have already dictated.
Yes.
Consider the Order 27 Rule, Order 41 Rule 27 application. If it is allowed,
Yes.
then judgment will not be passed. If it is not allowed, judgment will be passed. Judgment reserved.
Volume, oblige, Your Lordship.
Last line के लिखनी. Stop.
It's tired, I understand, my lord. No, if your lordship allows me, my lord, I would like to go through the case law in a case brief, my lord, in a different manner. Lordship will kindly see,
It is not parted metal, na?
not parted.
Part.
Now it will remain parted.
You are predicting.
Now I will try to take as little time as possible. Your lordship will kindly
No,
see page.
Take as much time as you required.
The will has been probated. Okay.
Where is the impugned judgment?
Let me take your lordship through. I have
Facts.
prepared facts. I will take come, my lord. The lordship will kindly see page 50.
1-5.
Yes. 51, your lordship may kindly see. 50 is the will. And there is a direction to produce the original copy of the will. This is the will in English. May I just read, madam?
Just a minute.
50.
Yes.
Yes. The Nipendra
It is translated copy or
no, it's
original
copy.
original will was in English language.
In Assamese language, page 51. My lord, in short, my lord, 3 brothers are there. After the death of the father, 3 brothers gets the property, but 1 brother died. So the property is required to be divided into 2. But the other brother says, my lord, the defendant says, my lord, he got the will of the other brother. So he is the owner of the whole property. The property is in Zorhat and 1 property is in Barwari. Sure. And some shares are there. Okay. So, and the present appellant, he stays in Ireland. Ireland, so he is.
You were the defendant.
I was the defendant. I was one of the brothers. 3 brothers are there. So property, as per law, my lord, it should have been divided into 3, but 1 brother died. So property should have been divided into 2. Now the present the defendant, my lord.
Whose will is this?
He is the brother, my lord.
Brother's will.
Brothers.
Not father's will.
Not father's. So one of the brother, he says, my lord, your lordship, I'll just read this.
So father's property, all 3 brothers inherited.
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 Inherited. 3 brothers, 1 died. So he shared, my lord, he says he shared this.
When he died, after, before father's death or
Yes, before father's death. No, after father's death.
after father's death. So after inheritance, he died.
After inheritance.
And after inheriting his father's property,
he died.
he died.
So
Your
his
number.
His share of the property, my lord, 1/3,
He has bequeathed.
Yes.
And you are opposing it.
I'm one of the brother. I'm opposing it. I'm saying, my lord, whatever I said, I'll read that, my lord. I'm saying, my lord.
You are brother number 1, 2, or 3.
I'm brother number 1, I think. Devendranath?
You are eldest or youngest or
Eldest. Huh? Nependranath is the eldest. I am second, I think.
he died. Nipendranath
I
died.
died.
You are number 2.
Number 2.
And respondent is number 3.
He is the youngest. My lord, your lordship will kindly, I'll come
So
from.
Nipendranath bequeathed his share to the present
This is
respondent.
what the claim is.
And probate was granted.
Probate was done.
And you are opposing that.
I'm opposing.
Okay, okay.
My lord, your lordship, I'll just read this will. I, Nipendranath, aged about 66 years, son of late so-and-so, resident of so-and-so, today sign this will for my movable and immovable properties with full knowledge and good health. The land mentioned in Schedule K, owned by me, along with my brother Sri Devendranath Thukon, I am Devendranath Thukon, appellant, and Sri Birendranath Thukon, as inheritance, and I am the owner of 1/3 of the said land. Moreover, the land mentioned in Schedule KHA is owned, that is Jorat, is owned by me, and by inheritance, I am the absolute owner of the said land. Besides this, in Schedule Go, the 7 numbers of shares, Bahini Tea Company is in my name. The details of the properties mentioned herein above are described in schedule below. I wish to give my properties to my younger brother, Sri Biren Phukon, son of late so-and-so, resident of so-and-so, Baruwari, Gauhati. The property is situated there, mother, in Baruwari, very valuable property. It may be mentioned that my younger brother was extending all kind of help on me during my hard days, and being satisfied, I give all my properties to him by this will. After my death, he can file due probate case before the court. So this is schedule co property is 1/3 portion of the land. Total so and so covered by Kiraz Miyadi Patta, Urubari Moja. This is Baruwari property. And schedule 6 is my lot. Schedule Kho is 1 bigha 3. This property is also 1 bigha, I think. Yeah? 1 bigha. Schedule Kho is also 1 bigha some. I'll give the details. Schedule Kho is Jorhat property and Schedule Go is the shares in respect of this thing. Your Lordship will kindly see it is witness is Mrinal Das, Siddharth Datta, and written by Nipendranath Phukon. Now your Lordship will kindly see the original. 51. What I understand from the law, my lord, from the very look of the my lord will is suspicious. I don't have to take your lordship through anything. Very look. How the
Space between the lines.
squeezed in.
Squeezed in.
Everything has been squeezed in. And his signature is below. Signature means that thumb impression and signature is right bill. And 2 signature is there. This will was executed in the house of the Apple of the opposite party. So this is what the will is, my lord. Everything is squeezed in. The court has got a duty, conscious duty to ask itself whether it has been written voluntarily, whether he was in good hand, whether this can be accepted. So therefore, my lord, before coming to the my lord, all the depositions and all, I would like your lordship to go through 1 or 2 judgments. My lord, your lordship will kindly see this judgment. It will also Meena Pradhan. I'll take your lordship for the evidences. Meena Pradhan. It is the conscience of the court, my lord. Even if I do not file written statement, and they have done it, my lord, because, my lord, in the cross-examination, the appellant said that it is his signature. Actually, it should have been, it is not, I do not know his signature, but wrongly it has cropped in. So therefore, I filed an application for
re-examination of the
for re-examination of the witness. If necessary, your lordship consider the petition. So this judgment, your lordship will kindly see paragraph. Issue was in paragraph 6. The issue that arises for consideration is whether there are sufficient grounds that warrant interference with the concurrent findings of the fact upholding validity of the will. Now, before delving into the facts of the case, it is pertinent to reproduce the relevant provisions dealing with the validity and execution of the will. Section 3, my lord, these conditions are there. The testator shall sign or shall affix his mark to the will. The signature or mark of the testator or the signatures of the persons signing for him shall be so placed, the lordship will kindly see, that it shall appear that it was intended thereby to give effect to the writing as a will. As a will. So if your lordship takes into consideration the will itself, which I have shown to your lordship, that itself belies the contents of the will, my lord. So place that it shall appear that it was intended thereby to give effect to the writing as a will. Now, sections Evidence Act, if a document is required by law to be attested, it shall not be used as evidence until one attesting witness that is there, if there be any attesting witness alive, subject to so and so. Now, if your lordship comes to paragraph 9, a will is an instrument of testamentary depositions of property. It is legally acknowledged mode of bequeathing a testator's property during his lifetime to be acted upon on his her death and carries with it an element of sanctity. It speaks from the death of the testator, since the testator at the time of testing the documents for its validity would not be available for deposing as to the circumstances in which the will came to be executed. Stringent requisite for the proof thereof have been statutorily enjoined to rule out the possibility of any manipulations. Now, paragraph 10, all these parameters are there. I will take your lordship to Roman 5. All these things are there. Roman 5. The attesting witness should speak not only about the testator's signatures, but also that each of the witnesses had signed the will in the presence of the testator. Now, again, 9, my lord. The test of judicial conscience. 9, my lord, I'll take your lordship to 9.
Yes.
The test of judicial conscience has been evolved for dealing with those cases where the execution of the will is surrounded by suspicious circumstances. It requires to consider factors such as awareness of the testator as to the content as well as the consequences, nature, and effect of disposition in the will. Sound, certain, and disposing state of mind and memory. This should be the question before the court. It is the conscience of the court which should be, my lord, in mind, my lord, for the purpose of deciding the will. And memory of the testator at the time of the execution. One who alleges fraud, 10, my lord, fabrication, undue influence, etc. has to prove the same. However, even in the absence of such allegations, if there are circumstances giving rise to doubt, then it becomes the duty of the propounder to dispel such suspicious circumstances by giving a cogent and convincing explanations. There was no meaning for squeezing all these sentences in a will. The will is a very solemn document, manner. It has to be done in a very nice manner, and the sentences should have been written very nicely, manner. It was done by a writer. Suspicious 11. Suspicious circumstances must be real, germane, and valid, and not merely the fantasy of the doubting mind. Whether a particular feature would qualify as suspicious would depend on the facts and circumstances of each case. Any circumstance raising suspicion legitimate in nature would qualify as a suspicious circumstance. For example, a shaky signature, a feeble mind, an unfair and unjust disposition of property. The propounder himself taking a leading part in that making of the will, under which he receives a substantial benefit. In short, apart from statutory compliance, broadly it has to be proved that the testator signed the will out of his own free will. At the time of execution, he had a sound state of mind. He was aware of the nature and effect thereof, and the will was not executed under any suspicious circumstances. If your lordships allows me to submit, my lord, I will say that the will itself shows that it is a suspicious and it is not in proper, not done in a proper manner, my lord. My lord, next, your lordship.
No, only because it appears that the writing is squeezed or the gap between the lines.
Besides that, the other things are there. But itself, on the face of it, it shows signature, the way the signature has been put below and the writing has been squeezed. It shows, my lord, that doubt is there on the face of it. And ultimately, it's a property belonging to my mother, my brother. My lord, I'll just read, my lord, I'll come back to the depositions. And your lordship will say, my lord, paragraph that 2006 Allahabad High Court, paragraph 6. My lord, paragraph 12, I'll read the below portions, my lord. Paragraph 12, it is Supreme Court decision has been quoted. My lord, paragraph 12 in the middle portion, the law relating to the manner and honors, your lordship has said.
Yes,
Got it, my lord? After about
yes, yes.
8 lines or so.
Yes.
The law relating to the manner and honors of proof and also the duty cast upon the court while dealing with a case based upon a will has been examined in considerable detail in several decisions of this court. A constitution bench of this court in Shashi Kumar Banerjee versus so and so succinctly indicated the focal position in law as follows. The mode of proving a will does not ordinarily differ from that providing any other document except as to the special requirement of attestations prescribed in the case of a will by section 63 of the Indian Succession Act. The onus of proving the will is on the propounder, and in the absence of suspicious circumstances surrounding the execution of the will, proof of testamentary capacity and the signature of the testator as required by law is sufficient to discharge the onus. Where, however, there are suspicious circumstances, the onus is on the propounder to explain them to the satisfaction of the court before the court accepts the will as a genuine. Where the caveator alleges undue influence, fraud, and coercion, the onus is on him to prove the same. Even there are no such pleas, but the circumstances gives rise to the doubts. It is for the propounder to satisfy the conscience of the court. The suspicious circumstance may be as to the genuineness of the signature of the testator, the condition of the testator's mind, the depositions made in the will being unnatural, improbable, or unfair in the light of the relevant circumstances, or there might be other indications in the will to show that the testator's mind was not free. So this is, I escape, my lord, I come to paragraph 16. The 16, my lord, paragraph 17, my lord, sorry.
Yes.
My lord, below, my lord, the place and time on which the will was written, the physical and mental capacity of the testator at the time of the execution, these are to be ascertained by the court itself, even if there is no plea. The relationship of Sri so-and-so, the other witness with the testator, the reason for which the testator desired to execute the will to a distant relative and to exclude his wife and daughters have not been sufficiently explained. There is absolutely nothing on record to show as to why the testator excluded his wife and daughters and gave his entire property to the plaintiff. The testator died on so-and-so alleged execution of the will in which he had admitted that he was so ill that he was not able to go to the office of the registrar. The propounder has not adduced any evidence regarding the health of the testator. In the absence of any evidence to remove these suspicious circumstances surrounding the execution of the document and the physical and mental condition of the testator, the propounder has not satisfied the court's conscience. The document does not speak for the testator. Now, next, your lordship will kindly see that page. I'll take just little time. Next, disseminate. Kobita. Then it will become easier for me to. Paragraph 24(1). कॉपी नहीं दिया आपको? कॉपी तो दिया ना, कॉपी तो दिया तुम्हारे दिबले को ना 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 तुम्हें कॉपी दिबले हो ना এনে কেন করে নি মই দি আছো কপি এটো লৈ লচোন এটো 2021 1 SCC Sorry, তোমার কপিটি দিব, সদায় কপি দিব না। Paragraph 24(1), your lordship will kindly see that. I'll not take time. 24:1, may I take it? Read it?
Yes, yes.
A three-judge bench of this court traversed through the vistas of the issues related with the executions and proof of will and enunciated a few fundamental guiding principles that have consistently been followed and applied in almost all the cases involving such cases. The synthesis and exposition of this court in paragraph 18 to 22 of the said decisions could be usefully reproduced as under. Your Lordship will take the next page, and in the middle, Your Lordship will kindly see. All these sections are there. I can read, my lord, from the next page. Under section 67, after about 3 sentences, if a document is alleged to be signed by a person, any person, the signature of the said person must be proved to be in his handwriting. And for providing such a handwriting under section 45 and 47 of the Act, the opinions of experts and persons acquainted with the handwriting of the person concerned are made relevant. Section 68 deals with proof of the executions of the document required by law to be attested, and it provides that such a document shall not be used as evidence until one attesting witness at least has been called for the purpose of proving its execution. These provisions prescribe the requirement and the nature of proof which must be satisfied by the party who relies on the document in a court of law. Similarly, section 5963 of the Succession Act are also relevant. Section 59 provides that every person of sound mind, not being a minor, may dispose of his property by will, and the 3 illustrations to this section indicate what is meant by the expression. A person of sound mind, in the context, section 63 requires that the testator shall sign or affix his mark to the will, or it shall be signed by some other persons in his presence and by his direction, and that the signature or mark shall be so made that it shall appear that it was intended thereby to give effect to the writing as well. This section also requires that the will shall be attested by 2 or more witnesses as prescribed. Thus, the question as to whether the will set up by the propounder is proved to be the last will of this testator has to be decided in the light of this provision. Has the testator signed the will? Did he understand the nature and effect of the dispositions in the will? Did he put his signature to the will, knowing what it contained? That is the understanding of the court should be. Stated broadly, it is the decisions of these questions which determines the nature of the finding on the pattern on the questions of the proof of the will. It would be prima facie be true to say that the will has to be proved like any other document, except as to the special requirement of attestations prescribed under section 6. Now, this paragraph, next paragraph, my lord. However, there is one important feature which distinguishes wills from other documents. Unlike other documents, the will speaks from the death of the testator. And so, when it is propounded or produced before a court, the testator who has already departed the court or world cannot say whether it is his will or not. And this aspect naturally introduces an element of solemnity in the decisions of the questions as to whether the document propounded is proved to be the last will and testament of the departed testator. Even so, in dealing with the proof of wills, the court will start on the same inquiry as in the case of proof of document. The propounder would be called upon to show by satisfactory evidence that the will was signed by the testator, that the testator at the relevant time was in a good and disposing the state of mind, that he understood the nature and effect of the disposition and put his signature to the document of his own free will. Ordinarily, when the evidence adduced in support of the will is disinterested, satisfactory, and sufficient to prove the sound and disposing state of testator's mind, his signature as required by law, courts would be justified in making a finding in favor of the propounder. In other words, the honors of propounder can be taken to be discharged on proof of the essential facts just indicated. There may be, however, cases in which the execution of the will may be surrounded by suspicious circumstances. The alleged signature of the testator may be very shaky and doubtful, and evidence in support of the propounder case that the signature in question is the signature of the testator may not remove the doubt created by the appearance of the signature. The condition of the testator's mind may appear to be very feeble and debilitated, and evidence conduced may not succeed in removing the legitimate doubt as to the mental capacity of the testator. The dispositions made in the will may appear to be unnatural, improbable, and unfair in the light of relevant circumstances, or the will may otherwise indicate that the said depositions may not be the results of the testator's free will and mind. In such a case, the court would naturally expect that all legitimate suspicions should be completely removed before the document is accepted as the last will of the testator. The presence of such suspicious circumstances naturally tends to make the initial sonas very heavy, and unless it is satisfactorily discharged, courts would be reluctant to treat the document as the last will of the testator. It is true that if a caveat is filed alleging the exercise of unsound, undue influence, fraud, or coercion in respect of the execution of the will propounded, such pleas may have to be proved by the caveator. But even without such pleas, circumstances may raise a doubt as to whether the testator was acting of his own free will in executing the will, and in such circumstances, it would be a part of the initial onus to remove any such document. Apart from suspicious circumstances to which we have just referred in some cases, the wills propounded disclose another informative. Propounders themselves take a prominent part in the executions of the wills, which confer on them substantial benefits. If it is shown that the propounder has taken a prominent part in the executions of the will and has received substantial benefit under it, that itself is generally treated as a suspicious circumstances attending the executions of the will, and the propounder is required to remove the said suspicion by clear and satisfactory evidence. Now, my lord, in this same line, the other paragraphs also deals with, my lord, same line. I'll just read one paragraph, page 257, middle portions. The suspicious circumstances, my lord, may I read, my lord?
Yes.
The suspicious circumstances may be as to the genuineness of the signature of the testator, the conditions of the testator's mind, what was the mind in writing the will in such a squeezed manner, my lord. The disposition made in the will being unnatural, improbable, or unfair in the light of relevant circumstances.
No,
or there
by squeezed manner, what you mean?
Well,
That-
there is no space, as if, my lord, there was dart of paper.
So what is your submission?
So that itself shows, my lord, and the putting the signature down below. That
Yes.
itself raises a
So,
suspicion.
Is it shows that the signatures were obtained on a blank paper?
Yes, this is.
Do you want to submit that?
Yes, this is what I submit. It on the face of the record, on the face of the will itself shows, my lord, if I see the will, oh, somebody has written it after getting the signature signed paper from somebody.
Okay.
So there I'll ultimately, it depends upon facts of the case. All the other paragraphs says this only, that ultimately they're conscious of the court. Even if I do not file a written statement. The last one.
But there are two attesting witnesses.
Yes, it is there. I'll come to that. Even if it is there, my lord, I'll come to that. There are some things are there. But ultimately, if your lordship is satisfied that this is there was no reason to write it in that manner. and whether he was in good health. Who is going to prove that? Well, there your lordship will kindly see, this is a Supreme Court decision, paragraph 11. 11,
Paragraph 11.
11. These are some of the same things, my lord, which have been stated in other judgments. 6th, maybe. 6. 11th, even 6th. My lord, paragraph 6, your lordship will give. Other things your lordship has already gone through the other judgments.
Para 6.
Para 6. 11 paragraph 6. Subparagraph 6 of 11, para 11. These are some of the paragraph 6, my lord, 3 questions need to be asked by the court, and the answers so produced should be to the satisfactions of a prudent mind. Mathematical precision is not to be looked for. There, has the testator signed the will? Did he understand the nature? The effect of the dispositions in the will, did he put his signature on the will knowing what it contained? So your lordship will kindly do to record this, and I come to your lordship the petition, probate petition, page 41. Broadly, my lord, the proposition of law is the court's consciousness has to be, my lord, satisfaction to the satisfaction of the court, whether the will is. I need not put my written statement. I may have done some mistake, but it is the satisfaction of the court. I read this, my lord, petition, paragraph 42, probate petition.
Yes.
The petitioner is a permanent resident of Barwari. Now, the opposite party is the elder brother of the petitioner, who is presently residing in Dublin, Ireland, and is a citizen of Ireland. That the petitioner said that let Mohini Nath Phukon had 3 sons, namely the petitioner, the opposite party, and one Nipendranath Phukon. They said deceased Nipendranath Phukon was also elder to the present petitioner. That the petitioner says that on the death of said Mohini Nath Phukon, the petitioner, the opposite party, and said Nipendranath Phukon inherited 1 bigha 1 katha, 17 lachas of land covered by so and so Moja Ulubari, that is Barwari property, my lord, 1 bigha 1 katha. Along with an Assam type houses standing thereon.
This Nipendranath
My lord,
Phukon,
Phukon.
whether he had any other heirs.
Huh? No other heirs, my lord. 3 brothers. Huh?
At what age he died?
He died at the
66.
66, I think, yes.
So he was, whether he was unmarried?
He was unmarried.
Unmarried?
Unmarried. Huh?
Okay.
He was unmarried. He was unmarried, yes.
Okay.
The aforesaid land and houses are not yet partitioned. There was a suit, my lord, by the present appellant, and suit has been decreed as regard 1/3 of the property. He is in occupation of this whole of this property of 1 bigha 1 katha 17 lachas at Barwari, and the suit has been decreed. Suit has been filed by the present appellant. 1/3 of the as regard 1/3 of the property before the filing of this probate petition, and the suit has been decreed. But present defendant is continuing with the possession of the property. Yeah. And Nipendranath, my lord, the second son, my lord, he stayed in Jorhat and he died there only, my lord. The aforesaid land and houses are not yet partitioned and presently in the exclusive occupations and possession of the petitioner. That is said deceased Nipendranath Phukon was residing at so-and-so, Jorhat, and he was a bachelor. The said Nipendranath Phukon died on 2009. That the petitioner said that the said deceased Nipendranath Phukon was the exclusive owner and title holder of land measuring 1 bigha 3 katha 14 Lachas of Jorat block, block number 3, and a house standing thereon. Besides the said landed property, the deceased Nipendranath Pukon had also 7 numbers of shares, that is share number so and so. The petitioner said that the petitioner, being the younger brother of said Nipendranath Pukon, the said deceased had loved the petitioner, as the petitioner always kept a good relationship, maintained and look after the deceased till his death. On the other hand, the opposite party, who is residing at Ireland, at no point of time had kept any contact with his deceased brother and even did not attain the Sardha ceremony held at Bahani Tea Estate Post Office so and so. All formalities, duties, last rites as per the Hindu rites was done by the petitioner. Rather, during the lifetime of the deceased, the opposite party claiming his right, title and interest over the land and house situated at Gauhati instituted a title suit number so and so against the petitioner and the said deceased brother Nipendranath Pukon. Because of this reason, the deceased had no good relationship with the opposite party. That is 1/3 of the property out of the 3 that has been decreed. That the petitioner says that after the last rituals being over, as there was none to look after the house of the deceased at Bahani Tea Estate, so and so, where he was residing, Jorat, where he was residing till his death, the petitioner was allowed to bring all his files, papers, and documents, and accordingly the same were brought by the petitioner to Gauhati. The petitioner states he had no family. He brought all these documents. That's what he says after the death. The petitioner says that after the death of the deceased, the present opposite party initiated a partition case number so and so before the landed circle officer Gauhati Revenue Circle in respect of the landed property in Gauhati. Accordingly, the petitioner was asked by the landed circle officer to file objections, if any in that case. The petitioner says that at the time of preparing the objection, particularly in the month of June 2011, while the petitioner was searching for the documents relating to the land of Gauhati, the petitioner traced out a copy of will dated to 23/2009. This is how he gets the will in the said files of the deceased, which was executed by the deceased Nipendranath Pukon in respect of this undivided 1/3 shares of the land and houses at Gauhati, the entire land and houses at Jorat, and the shares of Bahani Tea Estate in favor of the petitioner as an execution of the will. This is a story made out how he got the will in his favor, which was made in the year 2009, and he gets it in the year 2011 out of the files collected by him from the Jorat. Petitioner states that having found the said will or testament of the deceased, the petitioner in his objection, this itself shows, man, it is a made up story. So that having found the said will or testament of the deceased, the petitioner in his objection has clearly stated about the said will executed by the deceased in his favor. The petitioner further says that on being asked to the writer of the said will as well as to the witness, the said fact regarding execution of the will, this was executed in his house only, of the deceased Nipendranath Pukon, was confirmed by said writer, namely Rajendra Kumar Sharma, and the witnesses Minal Das and Siddhartha Datta. Copy of the will your lordship has seen. The petitioner says that the said will is the last will of the deceased Nipendranath Pukon executed in favor of the petitioner as executor of the will in respect of the properties mentioned in the schedule so and so of the will, which has been fully described in the schedule. The petitioner said that this is the last will and wish of the deceased Nipendranath Pukon. How he knows, my lord, the last will or not? As per his wish, and will the present application will the present application has been preferred before this honorable court for granting probate in respect of the will. That the petitioner says that besides the present application, no other application has been filed. So this is the plot of land, my lord, and the shares and the land at Jorat. Description is there, given in the schedule. My lord, your lordship will kindly see page 52. Written objections. that there is no cause of action, so and so, my lord, that the instant probate proceeding is not maintainable in law, that the probate proceeding is frivolous, vexatious, that the will in question is a manufactured one, the petitioner in collusion with the witnesses and writer prepared the will for illegal gain, and such the probate application is liable to be dismissed. Petitioner took signature of the testator in blank papers under duress and coercion, and after his death manufactured the will wrongfully to gain illegally. That the petitioner was ordinarily residing at Jorhat and was suffering from a different ailment and used to come to Gauhati for treatment and resides in the ancestral house. So this is the story, my lord. He was ill and he used to come to Gauhati for treatment, resides in the ancestral house, which is under the occupation of the petitioner. The petitioner and his son were eyeing on the property of the testator and forcefully took his signature on the blank papers, and after his death converted the said papers into the will, and as such the probate application is said liable to be dismissed. That the will so produced by the petitioner is not the will of the Nipendranath Phukon. That the said that the so-called will itself does not inspire confidence to be genuine, as the thumb impression and signature of the testator is behind the signature of the so-called witnesses. The thumb impression is also not the testator. So we have stated this, that the testator was not in a sound and disposing state of mind and health before his death and had no mental capacity to think. Moreover, he was under forceful confinement of the petitioner. That the alleged signature of the testator is very shaky and doubtful, as appears in the so-called will, and as such the disposition made in the will are unnatural, improbable, and unfair in the light of the prevailing relevant circumstances, and the eighth disposition was not the free will and mind of the testator. That the will suffers from undue influence, fraud, and coercion, and such the probable application is liable to be dismissed. That the will is surrounded by, your lordship will escapes, come to paragraph 17, that with regard to statements made in paragraph 4, the answering opposite party beg to state that the petitioner, after the death of their father, has been enjoying the usufruct of the ancestral property at Gauhati. He is in possession of the property, my lord, and he has not left the possession of the 1/3 of the property which the petitioner, my lord, got it by way of that decree on the basis of the suit filed by him. And now he doesn't want to give any the share of his brother also, and had not given the shares thereto, thereof to the answering opposite party and deceased brother late Nipendranath Phukon, despite oral demands on various states. Owing to selfish way of enjoyment of the properties, differences have arisen between the two parties. Besides, the petitioner had constructed 8 shops rooms in the early part of the year 2005 without obtaining consent of the opposite party, and has rented out the same to different persons and has been enjoying usufruct thereof selfishly. Whereupon answering opposite party demanded from the petitioner on 2001 write notice in writing for partitions of the said property, but the petitioner refused. The petitioner not only refused to the proposal of partition, but has denied the title of the answering opposite party. Under the circumstances, the title of the answering opposite party had become clouded, and as such, the answering opposite party filed title suit number so and so, paying for decree for declaration of his right title and interest to the extent of 1/3 share in the ancestral property. The learned Munsif Gauhati by judgment dated so and so decreed the suit declaring right title and interest of the answering opposite party to the extent of 1/3 share in the ancestral property. Be it mentioned here that the plaintiff has constructive possession over the suit property in the capacity of co-surer. It shows, my lord, he is a greedy man.
No. The judgment was delivered on 1/8/2007.
7, yes. Thereafter, they filed thereafter. This is as regard that 1/3 property when his brother was alive. When Nipendranath.
Your brother died in
2009.
2009.
So,
And the will was discovered in 2011.
yes. So despite this suit, my lord, having been decreed, the petitioner, the plaintiff, my lord, is in possession of the property and he doesn't want to share that. That shows that he is a greedy person and he doesn't respect his brother. Even the Nipendranath property was also not divided. So in the meantime, the brother of the parties, Nipendranath Phukon, died intestate, and the answering opposite party requested the petitioner to amicably partition the property. But as usual, he did not respond to the request of the answering opposite party under the circumstances. The answering opposite party filed petition suit in Gauhati for partition so and so. It is to be mentioned here that the petitioner appeared in the case and filed his objections and contesting so and so. Paragraph 19, that with regard to statements made in so and so, the answering opposite party begs to state that after the death of their brother, late Nipendranath Phukon, the land at Jorhat was duly mutated in the joint name of the petitioner and the answering opposite party as his legal heirs by order dated 2011 passed by the circle officer Jorhat so and so. That the statements made in paragraph 7 of the probate applications are not correct and are hereby denied. It is to be mentioned here that the petitioner never looked after late Nipendranath Phukon, who was residing in Jorhat and who used to come to Gauhati for treatment. While late Nipendranath Phukon, not keeping well for some time, came to Gauhati for his treatment. In the month of November 2008, the answering opposite party came to Gauhati for his treatment. The answering opposite party, in consultation with his deceased brother Nipendranath Phukon and his son and his cousin Justice so and so, decided to set up a trust to look after his brother Nipendranath Phukon. Accordingly, all formalities were completed, but the petitioner and his son did not allow him to go out of the house and confined him in the house, and as such the trust could not be formed. Paragraph 22, my lord, that with regard to statement made in so and so, the answering opposite party begs to state that the pendency of the partition case number so is a matter of records. It is absolutely incorrect that the petitioner in the month of June 2011, while searching for the documents relating to the land of Gauhati, he traced out a copy of will dated so in 2009 in the said files of the deceased. The answering the opposite party begs to state that the so-called will is afterthought of the petitioner, and he manufactured the aforesaid and became sole beneficiary. The answering opposite party further states that the will is not the will of the deceased brother Nipendranath Phukon. The petitioner, in collusion with witnesses and writer, manufactured a will to gain illegally. The statements made in paragraph so and so are not correct, are hereby denied. The answering opposite party begs to state that the so-called will is not at all a will of late Phukon. The same is a manufactured one made in collusion with the witnesses and writer, and as such the petitioner is not entitled to probate of the will. It is not out of place to mention here that the petitioner was found guilty of forging signature of the answering opposite party when he forged signature of the answering opposite party in a letter by which the answering opposite party was shown to have agreed to transfer his father's share of Balonity estate in the name of petitioner's wife, and the said letter should have in the files of the Gauhati estates. So this is the objections. Your Lordship will kindly see the examinations in chief of the PW1, page 59. PW1, that is the defendant petition, the opposite party here, my lord. Now, paragraph 2, that I state that our father, late Mohininath Phukon, had 3 sons, including me, the opposite party Devendra, and the deceased testator of the will. On the death of our father, I, along with my aforesaid 2 brothers, inherited 1 bigha, 1 katha, 17 letters of land, covered by Dag number so and so, some along with an Assam type house standing thereon. The aforesaid land and the houses are not yet partitions, and presently the same is exclusively in my occupations and possessions. So he doesn't want to give possession of the land, even after the judgment decree. That I state that the deceased testator of the will, Nipendranath, who was residing at Bahanit Estate, Jorhat, and he was a bachelor. My said elder brother Nipendranath Phukon died in the year 2009. I state that my said deceased brother and the testator of the will Nipendranath Phukon was the exclusive owner and title holder of the land measuring 1 Bega 3 Katha 14 Lachas at Jorat and some shares, a block and a house standing thereon. Besides the said landed property, my deceased brother Nipendranath Phukon had also 7 numbers of shares in so and so Bahaniti states. That I state that I being the younger brother of my said brother and the testator of will, Nipendranath Phukon, loved me as I always kept good relationship, maintained and look after him till his death. On the other hand, the opposite party who is residing at Highland at no point of time had kept any contact with his deceased brother and even did not attend the Sadar ceremony held at Bahaniti States, and all formalities, duties, last rituals, etc. Was done by him. Rather, during the lifetime of the testator, the opposite party claiming his right, title and interest over the land, house and situated in Gauhati instituted a suit so and so against me and my said deceased elder brother Phukon, the testator of the will. Because of this reason, my said deceased brother Nipendranath Phukon had no good relationship with the opposite party. Why, he was not even residing in that place. That I state that after the last rituals being over, as there was none to look after the house of my deceased brother, Nipendranath Phukon, so and so, where he was residing till his death, I was allowed to bring all his files. Who was allowed? He must have picked up himself. There is nobody in the house. Paragraph 7, that I state that after the death of my elder brother, the testator of the will, the present opposite party, initiated a partition case number so and so in respect of the landed property in Gauhati. Accordingly, I was asked by this learned circle officer to file objections, if any, in that case. At the time of preparing the objections, particularly in the month of June 2011, while I was searching for the documents relating to the land of Gauhati, I traced out a copy of will dated 2009 in the said files of my deceased brother Nipendranath Phukon, which was executed by my said deceased brother, the testator of the will in respect of his in undivided 1/3 share of the land and house at so and so. So this is the, and cross he says, my lord, page 63. The land described in will is our ancestral property and we are 3 brothers. Then paragraph 7, your lordship will kindly see. It is not, no, paragraph 6, my lord. There are 8 rented shops in our Gauhati property. We 3 brothers equally divide the rent amongst us. It is not the fact that I have falsely stated that the rent was divided equally. My second brother Nipendranath Phukon resides at Jorat and he died at Jorat at the age of 68 years. He was suffering from epilepsy and he came to my place at Gauhati for his treatment. Lordship will kindly see epilepsy and treatment. My said brother died unmarried, so his property should be divided in between me and my elder brother.
This is your Birendra Phukon's evidence.
Yes.
You are Birendra Phukon.
No, I'm Devendra.
Deven.
No question. My second brother was unmarried and therefore after his death, his property should be equally divided to us. I maintain a good relations with my elder brother.
Whose testimony is this? Your younger brother.
Elder.
Number 3.
Number 3 is the present, that probate application has been filed by him, Birendranath Phukon.
Yes, his testimony.
His testimony.
Okay.
My second brother was unmarried and therefore so. I maintain a good relations with my elder brother, but my second brother was not in good.
Why he is saying that my second brother was unmarried and therefore on his death, property should be equally divided between us, when he has bequeathed entire second property to him?
Some mistake maybe. I will not go into this aspect of the matter. Maybe he became emotional to say the correct.
You should take benefit of that.
Yes. That is true. But no, my lord, what has happened, my lord, in this case, I'll show because in recording the evidence in cross-examination, my lord, this petitioner, this present appellant has said the signature of the will is his. So therefore, the judgment has been passed, my lord.
Where?
I'll show that, my lord. So I maintain a good relationship. My next page, your lordship will kindly see. My
Where?
second, page 64, third paragraph, fourth paragraph. My second elder brother came to my house in the month of July 2009. Then he was missing thereafter. I searched for him and found him in the hotel. So it shows, my lord, he is not in good state of health. So therefore, it should have been his duty to prove that he was in good health at a time when the will was executed. Before his death, he was admitted to a hospital for his treatment of epilepsy. I do not know about who wrote the will. It was done in his house only, my lord. I do not know Birendra Kumar Sharma, the person. In the month of July 2009, I brought my brother to Gauhati for his treatment, and he was admitted to GMCH Gauhati, and he had gone to Jorhat in the so and so. My brother Nipendranath Phukon intended to give his share of the property, executed a power of attorney in favor of me. I have not filed the said power of attorney in my case. I have not stated about the will in my case. I have not filed the death certificate of my brother before the court. It is not fact that after the death of my father, I have submitted a letter to the management of Gauhati estate, which was written by my elder brother Devendranath Phukon, whereby he intended to gift out a part of his share of land to me. Next, my lord, my brother Nipendranath Phukon did not inform me about execution of a will before his death. A partition suit was filed for distribution of property amongst our brother. I did not mention about the will in the said partition suit. The attesting two witnesses of the will also did not inform me about the execution of the will. But they are their son's brother, my lord, son's friends. I'll show that the evidence will show, and their residence in Gauhati. My brother Nipendranath Phukon is a permanent resident of Jorhat. I know the writer of the will, Devendra Kumar Sharma, but he is actually Rajendra Kumar Sharma. Maybe a typing mistake. I will not go to you, but Devendranath Phukon. I do not know his residence. It is not a fact that my brother Nipendranath Phukon did not make any will. It is not a fact that the will was subsequently prepared on a blank signed paper. Both the attesting witnesses are friend of my son Rajiv Phukon. Your lordship will kindly take it. If it is the attesting witnesses are his son's friend, how he gets the will, my lord, in a paper in the records of the deceased Nipendranath Phukon? I do not know where the will was executed by my brother, but the attesting witnesses are friend of my son.
They also never informed.
No, I was in Ireland, man. I'm in Ireland.
No, they never informed Biren.
Page 78, your lordship will kindly see, PW2 says he was called to sign.
No.
Yes, yes.
What I am asking, that if the
Yes.
witnesses are son's friend of the beneficiary, normal
Absolutely.
assumption is that they would have
Will inform.
informed him.
Now, we in that circumstances, my lord, your lordship will say whether your lordship's conscience will be there that this will has been done in a proper manner. It creates doubt only, my lord. It's a doubtful proposition. His son's brother is there. The son's friends are there, witnessing witnesses, and he will not know the execution of the will, such an important document, where, my lord, the will, all the sentences have been squeezed in. I do not know where the will was executed by my brother. Why not your son's friends, witnesses? I do not know. It is not believable, my lord. It is not believable. I do not know how seriously my brother was ill at the time of making the will. Health condition, he says, doesn't know. Epilepsy was there. He went to hotel. He was taken to GMCH. So it was his duty to prove that at the relevant point of time when the execution was done, my lord, he was in a good condition, health condition. It is not the fact that the will was prepared by me after taking signature of two witnesses, and therefore the signature of two witnesses were taken above the thumb impressions of my brother. Now, PW2, your lordship will see page 75. Minal Das, he is an attesting witness that I am one of the attesting witness to the last will and testament of Nipendranath Phukon, dated so and hence competent to adduce evidence in the case. That I state that I was present at the time of execution of the last will and testament by said Nipendranath Phukon, and so that the said testator affixed his signature thereto, that the said testator acknowledged the said writing in his will, his last will and testament in my presence, exhibit so and so. That I state that the said Nipendranath Phukon, the testator at the time of execution of the will, was in sound state of mind and he signed the said will in presence of me and other two attesting witnesses, namely Rajendra Kumar Sharma and Sri. He is the writer, Rajendra Kumar Sharma is the writer, and Siddhartha Datta, out of his free will and volitions without being influenced by any of the induced from any corner. This is his statements, and page 78 is his cross. Nipendranath Phukon was a resident of Jorhat. Nipendranath Phukon, while coming from Jorhat to Gauhati, resides in the said house. I signed in the will in the house of Nipendranath Phukon at Gauhati. At Gauhati, Nipendranath Phukon means that Birendranath Phukon's house. Same place. Nipendranath Phukon was a residence, that is the residence of Birendranath Phukon. Nipendranath Phukon was a resident of Jorhat. Nipendranath Phukon, while coming from Jorhat to Gauhati, resides in the said house. It is not a fact that I knew Birendranath Phukon was the owner of that house. I know Nipendranath Phukon about 2 years prior to the execution of the said will. I met him while repairing a house behind the said house at Gauhati. Can it be believable? I was called by Nipendranath Phukon over telephone to sign on the will. At the time of execution of the will by Nipendranath Phukon, 2 other persons were also present at the house of Nipendranath Phukon. I do not know them, and their name is also not known to me. But in chief, he has said Rajendranath Phukon, Rajendranath Sharma and Siddhartha Datta, my lord. He has said in chief. I do not know them, and their name is also not known. The 2 persons mentioned in the 3rd paragraph above was not known to me. At the time of execution of the will, I do not know so and so. By the will, Sri Nipendranath has given his share of property of Gauhati, his shares of property of Jorhat, and shares of property T state to Birendranath Phukon. At the time of preparation of evidence on affidavit, I was informed by one unknown person, and accordingly I came and signed the affidavit. I signed, these are not believable facts, especially in respect of a will, my lord. It is very clear that the will has been signed in good health, at least when the my lord Birendranath Phukon himself said he was sick, suffering from epilepsy. He was sent to GMCH. I signed the exhibit after signing by Nipendranath Phukon. It is not a fact that exhibit 1 was a blank paper and having only thumb impressions of Nipendranath Phukon. PW3, page 83. Siddhartha Datta.
What is the date of the will?
The date of the will is 2009.
Date.
I'll come. 20 March 2009.
And when the testator died, Nipendranath Phukan died.
2011, I think.
2009 is the date of the will.
Yes.
And what is the date of death of Nipen Phukan?
22/9/2009.
So after making the will, he lived for 6 months.
Yes.
Okay.
And it was discovered in the year 2011. His ill health was admittedly, my lord, admitted by this Birendranath Phukan, private applicant. Now I'll read only PW3, my lord, rest of the matters I can do it another half an hour, next date, your lordship.
We will adjourn it today.
Yes.
We don't have much time.
Yes.
We'll keep it parted.
Yes.
Keep it parted.
Can it be taken this week or the next week? my lord?
Will be taken Tuesday.
Yes, it
Okay,
can be
Tuesday.
taken.
Tuesday as parted matter. Heard. Mr. B.D. Das, the learned senior counsel assisted by Mr.
H.K. Sharma.
H.K. Sharma, learned counsel for the appellant. Also heard Mr. S.P. Roy, the learned counsel for the respondent. The hearing could not be concluded due to paucity of time. It remained part heard. Let this appeal be listed again on Tuesdays, 28th July as part heard matter.
Deeply on that.
Baki. Remaining matter will be adjourned. We don't have time.
I was just praying if a date could be fixed for this.
Yes, what is your
Item number 21.
item number 21 at all?
It's an ex parte matter, lordship. The respondent have not entered appearance.
Second week of August. 11th,
Any date, if it could be on 13 in that case.
13th of August. Due to her Miss P.
P. Agarwal.
P.
Dr.
Agarwal, Dr. P. Agarwal, learned counsel for the. You are legal aid counsel.
Yes, lordship.
Legal aid counsel appearing for the appellant. None has appeared for the respondent. Due to paucity of time, this appeal could not be taken up for hearing. Let this be this appeal be listed for hearing on 13th of August 2026. Yes.
Similar program item 22. Interest is a very small matter.
Interest cases are not small.
No, it is small. So, if you must be very pleased to on 11th August.
Had Mr. A. Rashid, Baki same order on 11th of August.